We're going to start with one public hearing and then a couple work sessions, and this afternoon, another public hearing. So if we could introduce ourselves, Representative McIntyre.
Thank you, Madam Chair. Good morning, everybody. Matthew McIntyre, House District 18. Haven't done this in a while, so Lowell, Burlington, Greenbush, Passadumkeag, Clifton, Amherst, Aurora, Osborne, Great Pond, Dedham, Eastbrook, Mariahville, Otis, Beddington, Du Bois, and Cherryfield.
Nicely done.
Good morning. I'm Representative Chad Perkins. I represent District 31, which is southeast Piscataquis County.
Good morning. I'm Senator Scott Searway, and I represent District 16, which covers Waterville, Winslow, Oakland, Fairfield, and Albion.
Good morning. I'm Representative Bob Nutting. I represent the towns of Oakland, Smithfield, Mercer, Starks, and a portion of Sydney.
Representative Tavis Raw Cassenfuss, House District 57, Reedfield and Winthrop.
Representative Bunker.
Representative Steve Bunker, District 75, Farmington, and Chesterville.
Good morning, everyone. Nina Milliken, House District 16, Blue Hill, Brooksville, Castine, Cedric, Surrey, and Trenton.
I'm Senator Penny Beebe Center. I represent all of Knox County except for Idaho and the town of Washington. So, LD 2223. No. Yeah.
I got nervous.
Wrong day. Wrong day.
I'm 16 counties.
You what?
The 16 county song is starting.
Do we have anybody online for testimony? Welcome, Senator.
So good morning. Good morning, everyone. Senator Beebe Center, Representative Hassenfuss, and the esteemed members of the Joint Standing Committee on Criminal Justice and Public Safety. Good morning once again. I'm Senator Rachel Talbot Ross. I represent Senate District 28, which includes part of Portland on the peninsula, part of the Casco Bay Islands, and includes the University of Southern Maine campus. I am proud to be the sponsor of LD 2058, an act to require municipal and county jails to be available at all times for detention of persons arrested on criminal charges by Maine law enforcement officers. LD 2058 was filed as emergency legislation in the second session of the 132nd legislature to remove ambiguity in a long-standing Maine statute. So over the past couple of weeks, and particularly the last couple of days, I have had very, very productive meetings with Sheriffs Troy Morton and my own sheriff, Kevin Joyce. We have been actively discussing a way to arrive at language that is mutually agreeable. And I'm proud to say that we have reached a conceptual landing place that still achieves the core purpose of this bill without drawing any of the ire of the sheriffs. I will say that on behalf of Sheriff Morton and Sheriff Joyce, I have come to understand that they have been engaged with the entire Maine Sheriff's Association, of which they will talk about in their testimonies. Our conversations have included the ACLU and now include the Maine Department of Corrections. And we are all in this to try to find a way forward to bring back to this committee some revised language during the work session. The new bill language would require Maine jails to be available to people arrested by local, county, and state law enforcement and by the federal government, as long as the arrestee is charged with a crime. That's number one. And two, the arrest was supported by documented probable cause. I wish to express my deepest gratitude for their partnership in this work. My original purpose in sponsoring this bill was to clarify the core responsibility of Maine jails, to be available at all times to receive individuals arrested on criminal charges by Maine state, county, and local law enforcement officers. That's a really important point, that county jails be available at all times to receive individuals arrested on criminal charges by Maine state, county, and local law enforcement officers. This change was designed to align Maine statute with the legislative intent that underlies Section 1502 of Title 25. The legislative history on Section 1502 leaves no ambiguity about the legislature's intent. As amended in 1964, this statute was enacted to address a narrow and urgent problem: the absence of statutory authority governing cooperation between state and local law enforcement in the detention of persons charged with crimes under Maine law. The emergency preamble to the 1964 amendment makes this clear, explaining that, quote, arrest and detention of persons alleged to have committed crimes is a statutory responsibility of state law enforcement officers. Yet there was no statutory provision to ensure this detention until the proposed 1964 amendment. I've gone back and read the legislative record, and I can provide you copies of this at the work session if you so choose. This emergency legislation action immediately followed a dispute involving the city of Rockland, which had discontinued accepting persons arrested by state police and neighboring municipalities. The Attorney General back then issued an opinion stating that the city, as a subdivision of the state, could not refuse to accept individuals arrested for violations of state criminal law. The legislature then took emergency action to codify that opinion in 1964. Nothing in the legislative history of Section 1502 suggests an intent to mandate cooperation with federal authorities, especially those accused of civil infractions rather than criminal violations of law. To jump from a narrow fix about state and local cooperation back in 1964 to a mandate that local jails now must accept all federal detainees is a strained reading at best. Worse still, this interpretation could lead to legal and financial liability on behalf of our county jails. If a local jail assumes custody of a person the federal government illegally detained, that jail could face significant liability. This bill rightly spares our communities from avoidable and potentially costly litigation. Further, this change also provides clear statutory direction to ensure Maine's law enforcement professionals can do their jobs without unnecessary procedural limits while preserving local control. To those who have served their communities as law enforcement officers, you understand better than anyone the responsibility that comes with placing a person under arrest for criminal charges. In that moment, the law must be clear, and the next step must be certain. This legislation respects your professional judgment and ensures that when you detain someone under Maine law, there is no confusion about whether a jail must receive that individual. That statewide consistency is critical to maintaining both operations and public confidence in our system. This is about public safety. LD 2058 is about assuring that the statute reflects both the practical realities and our main values. This bill reaffirms an essential expectation in our criminal justice system that jails must reliably serve Maine law enforcement by providing clarity while respecting local autonomy. This bill strikes a careful and appropriate balance. I want to thank you for your time and consideration of LD 2058. I will say that the original bill is being changed to reflect the conversations that we're having with the Maine Sheriffs and now the Department of Corrections. So I do not want to waste a lot of your time doing a deep dive into the original language of the bill. Those who will testify after me, the sheriffs in particular, will be able to explain some of the ways in which we want to change this bill. We have just, I want to emphasize, I really truly want to emphasize that while this bill did come out of some concern that I had earlier last year during the summer of 2025, we have now reached a place of great consensus on the role of our Maine of county jails and the role of local, county, and state law enforcement and their responsibilities to detain individuals who have been accused of a criminal charge. So one of the key concepts to keep in mind as we debate this bill is civil versus criminal charges and documented probable cause in which to hold an individual in our county jails. That's going to be key to moving forward. We respectfully ask that you give us some time before scheduling the work session. There are a couple of scheduling challenges with our sheriffs, and our sheriffs want to be here in order to go through the entire work session with you. But I am proud to present this bill in collaboration with our Maine sheriffs, and I hope that you will take the time to listen to them and to consider the work that we are doing together on this bill. Thank you again for your time.
Thank you, Senator. Questions? Yes, Representative McIntyre?
Thank you, Madam Chair. Thank you, Senator. During your off-script verbal testimony there, you expressed that this was promulgated by a concern you had in summer of 2025. Can you elaborate on that concern?
I will. During the summer of 2025, the Department of Corrections issued a memo. Stephen French issued a memo August 20th, 2025, which I can provide to the committee, in which it stated that pursuant to Title 25, subsection 1502, that municipal and county jails, this is in statute, this is their quoting statute, that municipal and county jails shall at all times be available for detention of persons arrested by state or any other law enforcement officers. This statutory mandate requires county jails to accept individuals arrested by federal law enforcement officers. This was during a time when there were federal law enforcement officers in our state who were detaining individuals, and Cumberland County, and I think the Sheriff Joyce is on his way. Sheriff Joyce, Cumberland County was debating whether or not to renew a contract with the federal government in terms of detainees, federal detainees. And in the course of that debate, this Title 25 came up as whether or not the county jail still maintained that contract with the federal government. State law would require them to accept any person according to Title 25, that subsection. So this memo that was issued by Mr. French clarified that it was state law, that it was mandated to accept detainees for persons arrested by state or any other law enforcement officers. That interpretation of any other law enforcement officers, in my mind, I don't know about anybody else, was federal law enforcement officers. So I looked into it, and this bill was born out of that.
Representative Lookner?
Thanks, Madam Chair. Thank you, Senator Talbot Ross. So you're basically saying there are a lot of people in our jails right now who have not been charged with any crime.
I am not, thank you for the question, Representative. No, I am not saying that at all. I did reread a news article that was printed at the time in which Sheriff Joyce said that 2/3 of the detainees that were brought in by federal law enforcement, 2/3 of them were coming from out of the state of Maine, and they were just being held in the Cumberland County Jail. And then another significant portion of those people, and I can get the news article for this committee if they'd like, a number of those people had no charging instrument. They were not, there was no criminal charge in which to relate back to their detention. And so we were holding individuals in the Cumberland County Jail who apparently had some charge against them in some other area of this country, and we were holding them in our jail. And according to the contract that the Cumberland County had with the federal government, that was permissible. And then it was further permissible through this title.
Senator Searway?
Thank you, Madam Chair. This seems to be eliminating federal a lot, because it sounds like in your speech here, it's all about state and local and not talking much about federal. And then, you know, to me, this is like opening a book of saying that even, you know, the next thing could be that we're only going to have National Guard, not our military, the federal military to protect us. And to me, this is the same thing. And I think that you know, the federal officers are just as much police as the police here. And so, you know, I can relate to it because I've had to deal with both sides. And I think you're leaving out U.S. Marshals, you're leaving out a lot of situations where they take someone into custody and they may not have the affidavit right at that point because they may have a large number. It might be other instances where maybe they're bringing it, that sort of thing, but they are federal prisoners and they do pay to be housed. And I think that's why it said other. And also that probably leaves out even your protection here at I'm just trying to figure out, does this include like the Muskie building, federal officers? Does it leave out college police? Does it leave, this seems like when you take out other, it's taking a lot out of protection for the public.
Is there a question?
Yeah,
Senator?
you're taking out other, that's correct, right?
So there were a number of issues that you raised. Number one, it has nothing, there's no similarity to the example that you gave. So two things to keep in mind. The original intent of the legislation back in 1964 had nothing to do with the federal government. It was in order to, the town or maybe it's the municipality of Rockland, wanted some clarity on their liability in taking in those who had been arrested by law enforcement officers not connected to their town. And they really wanted to ensure that if that individual had been falsely accused, that they did not reap the liability by holding them in their county facility. So the original intent of this back in 1964, had nothing to do with what we're talking about now. And so this bill writes that intention, that legislative intention back in 1964. But the second point here is, and this is really important for the committee to understand, this is not taking the federal law enforcement out of this equation at all. It maintains the federal law enforcement ability to detain individuals. I was only referencing any other law enforcement officer to answer the representative's question as to how I got involved in this. I was curious about that. But the language for this bill really rests in keeping the local, state, and county law enforcement's ability is intact. The federal government's ability is intact. The bill requires the federal government to have a criminal charge and to document the probable cause. So federal government still has access to these county jails. We have not taken that away at all. I do respectfully, Senator, understand that federal law enforcement is law enforcement. And this bill does not do anything to change that equation in any way. They still can utilize our county jails as long as there is a criminal charge and there is probable cause that has been documented. And I will say this, in my personal view, when the Cumberland County Sheriff, Joyce, admitted that there were a number of individuals in his county jail that were being held because ICE, federal law enforcement, had asked for those individuals to be held. at that point, we've since learned that many of the people who were arrested by ICE had no criminal charges that were against them. They had no pending charge against them. They were not violating the law in any way. There are numerous examples, and if you'd like, I can bring them to you. There were numerous examples of innocent people being caught up in a sweeps in which they weren't accused of a crime at all, and they were being held in our county jail. And then many of them disappeared. We didn't know who had arrested them. We didn't know why they were arrested. We didn't know where they were once they were in the Cumberland County Jail. We had no idea where they were being sent to. We couldn't track any of that information. And I think that public safety demands transparency by all stakeholders within the criminal justice system. That was not transparency in my mind, Senator. And so this bill allows the federal government to still do their job. As long as there are criminal charges and there's probable cause.
Follow-up
Just to
question,
follow up
Senator?
on it, yes. So have you spoken with, had you invited or spoken with the other side, the federal side, to get clarity on this, on what their thoughts was on this bill?
Senator, all due respect, this is a state statute that I am trying to address. This is not a federal code at all. And I have not spoken directly with the federal law enforcement. And I will say to you, whether this resonates with this committee or not, but my obligation as a state senator, as a representative of the people of District 28, which was disproportionately impacted by these actions, my obligation is to look at the state statute and to make sure that the state statute reflects the best of our laws of our state. And so, no, I have not spoken with the federal government about a state statute that does not take away their ability to still do their jobs in terms of public safety, as long as there is probable cause and a criminal charge has been brought forth.
So this does not include the stakeholders on that side. And also, I'm just saying, how do you feel?
Senator Sewer, is there a question there? Point of order?
Yes, yes. How do you feel that leaving them out without them able to defend whatever you're trying to produce here when we're eliminating public safety?
Point of order, Madam Chair.
How
I feel
does
like
that
he's
work?
badgering
No.
the state senator.
Do you have a question?
Yes, I just said, how does that work if you eliminate half of that you're taking out, the federal side of this?
In all due
Public
respect,
safety.
Senator, I can answer the question.
It's not-
In all due respect, we are not, I will repeat this, and hopefully those who come after me will continue to repeat it. It's very, very important for this committee to understand we are not taking the federal government's authority out via this bill.
Right.
That is a full stop, period. I have explained once and I will explain it again. The federal government, in order to detain those in our county jail, would need to have a criminal charge and would need to have probable cause. Though that is the basic tenets of what it means for law enforcement to do their jobs in order to protect public safety. Thank
you.
Probable cause is a pretty standard part of the obligation.
Thank you, Senator. Representative Milliken?
I think the senator's doing a great job of responding to what my question will be, but just to put a finer point on it, is there anything in this bill that would prohibit federal law enforcement from arresting someone who is likely to have committed a crime and putting them in a county jail in Maine?
There's nothing that would prevent them from
Thank you.
doing that.
Representative Hassenfuss?
Thank you, Madam Chair. And, Senator, so my understanding is the language in front of us is not necessarily the language that we hope that any final bill moved out of this committee would be. My understanding is that your hope is to get language prepared for the work session that essentially will say all police agencies, whether it be a state agency, a municipal agency, or a county agency, or a federal agency, can bring individuals who are arrested because they have violated a criminal statute, either on the federal level or on the state level, and that those individuals can be housed in a county jail. But short of violating a criminal statute, whether it be Maine officer or federal officer, that short of that, they are not required to be housed in a county jail. Is that globally what you're looking to get at?
Thank you for the question, Representative. I think in order to answer the question, what's really important for the committee to understand is that and perhaps you need the statute in front of you in order to continue this discussion. But I am not changing the language that says shall. I'm not changing the language that says shall. The language that we're proposing will not be a may, it is a shall. And so the mandate still is intact. Through the language that we hope to bring forward to you. What this does is clarify that for the federal law enforcement to detain individuals in our county jails, there needs to be a criminal charge and it needs to be supported by documented probable cause. That is the totality of the bill, is to ensure through Title 25, subsection 1502, we retain that shall, and it says by county, state, and we retain the language or any other law enforcement officers. It's retained in the language that you will see to come before you as an amendment. The criteria is, and I would think that those who are engaged in public safety would appreciate that criteria, that there has to be a charge, a criminal charge, and there has to be probable cause. That does not, in my mind, I don't understand how that would restrict any federal law enforcement officer from still doing their job, arresting and detaining and housing them in our county jails. That's not a restriction. There's no restriction there. So I just wanted to point out that that language stays intact.
Follow-up question, Representative Hassenfuss?
Yeah, so thank you, Senator. So essentially you're saying we're just holding every single police agency on no matter what level you are to the same standard, main agencies are the same standard as federal agencies, right?
That is correct, Representative. This aligns with what I believe, and again, you will hear from the sheriffs. This aligns what is currently being done within our state borders. We are currently operating under that that kind of criteria. And particularly Sheriff Morton and Sheriff Joyce can talk to you. This is about aligning the main law with, in many ways, with the standards that the county jails operate with now, standard 32. E1. If you look at the county jail standards, it's 144 pages, by the way, but if you look at section E1 talks about the standards. So this is about jail standards and main law. And the jail standard says that the evidence to document that we are holding individuals in our county jails, there has to be a written policy and procedure. I'm doing this off the top of my head because I did not write down the standard, but it's contained in our standards. And the way, so the evidence of meeting that standard is written policy and procedure. What is happening in our county jails is they actually do have that written documentation through a form that if the sheriff will allow me to share it, there is a form that Cumberland County uses, and it's called different things by different county jails. Some call it the safekeeping form. Some people call it the county booking bail form. It's an affidavit in support of a 48-hour hold. But there are forms that our county jails are using right now in order to have that evidence of meeting standard E1, which is the documented probable cause for holding someone. So this bill would align what we're currently doing in the state right now with our county jails throughout law enforcement that includes the federal government. So this is an alignment of a standard that we currently have, Representative Hassenfuss, and this bill honors that standard that we currently have in the state, and it applies it throughout any other law enforcement when they detain or arrest an individual and house them in our county jails.
Thank you. Representative McIntyre, did you have a question?
I did. Thank you. Thank you, Madam Chair. Hypothetical. If I understand your proposal correctly, this modernizes or updates the statute to allow federal, state, county, local to use the jails under a criminal charge, and Maine state law enforcement authorities to use the jail under civil. So that does carve out access to the jails for civil arrests made by federal authorities. Is that a correct understanding?
It carves out,
The federal authorities may not use the jails for civil infractions,
that is correct.
but every other Maine state law enforcement
That is correct.
can. Okay, so then the question I have is, are there any fiscal implications associated with that carve out if the federal authorities can no longer access the jails for civil arrests? Are there fiscal implications to the recipient jail?
That is a great question, Representative. I believe that's a question for the sheriffs to answer. My understanding of all of this is this bill is simply asking the federal government to do its job based on what we have experienced in the state, in which individuals who were not charged with a criminal charge, they had no criminal charge, and there was no supporting probable cause that was given at the time. This just aligns and holds everyone to the same standard, which I believe would not have a fiscal impact, but I don't run a county jail, so I would not be able to say. And then we have three fine sheriffs here that would be able to answer your question more specifically.
Representative Ardell?
Thank you, Madam Chair. My name is Donnie Ardell, and I represent House District 6. Hello, Senator Talbot Ross.
Good morning.
Looking through, listening to some of your commentary on the bill, if a probable cause determination was provided to the jails, would that satisfy your concerns about their detention?
Thank you, Representative. It would.
Okay, and the reason I ask that is because it's my not only understanding but professional experience that all immigration administrative charges are based upon a finding of probable cause.
I appreciate your opinion about that. I just know of tens of people, maybe hundreds, who have been arrested, and that was not evident.
To who?
To courts who are now letting them, who have now rescinded those orders and have restored those people to their communities.
Well, you understand that
There's-
probable cause is not absolute certainty.
I understand. There were a number of individuals who were arrested, who were detained in our county jails, who had no criminal charge that had been placed upon them. And so I don't know what the evidence of probable cause was to detain those individuals. You could probably ask the sheriffs about that. But I do know a number of individuals who were caught up in a system in which there was no criminal charge, and therefore the probable cause didn't follow that arrest, and they were detained. I will say respectfully, Representative, you know that I'm not a law enforcement officer. I also know that you are. Or you've had a lot of experience at it. So these questions would probably be better for the sheriffs who actually held those individuals and are working with me on this bill.
I was hoping the bill sponsor would know maybe more about them,
I
but
believe I know enough to sponsor a bill, and I really find that a little bit offensive, Representative Ardell. I have presented a bill. I have answered all your questions. I've been working with the sheriffs to really bring to you a good statutory change, and I have done my homework, and I stand proudly with the knowledge that I have to present this bill.
I'm glad you do, and
I do.
You can take it however you'd like.
I
Thank
have.
you.
I appreciate that, Representative. I will say that this is a very difficult committee to present my bills in front of.
Point of order.
Excuse me. Senator Serway, did you have a question?
Yeah, so I'm just wondering if we can have our analysts actually reach out to US Marshals. I mean, this is mutual aid. We all have to work together. So we just need US Marshals. We need maybe ICE or MDEA. There's several federal groups that we work with. And I think that they should be involved in any decision like this, because to me, it's a one-sided situation where we're just looking at state and county and not, and even municipal oppose this. But anyway, I'm just trying to find at least a stakeholder group that could come up with an answer, because it sounds like we need to get all sides. That's all. So if we can reach out for those other groups, that's all.
Representative Lookner?
Yeah, Madam Chair, I'm concerned we're getting into work session territory.
Okay.
Okay.
Are there any other questions for Senator Talbot Ross?
I would just, Madam Chair, I would just ask that you hear from the sheriffs. This is the work they do each and every day. It's not the work that I do each and every day.
Yeah.
And I believe that they will have a lot more specificity to provide the committee on answers to some of your questions. I respectfully ask that you allow them to testify and provide you with that information respectfully.
Okay, thank you very much.
Thank you.
Is there anyone else that would like to speak in favor of this legislation? Sheriff.
Morning,
Good morning.
Senator Bibi Sana, Representative Hafson Fuss, and distinguished members of criminal justice. My name is Troy Morton. I am the sheriff of Penobscot County and have the privilege of serving as the president of the Maine Sheriffs, also on the board of directors for the National Sheriffs. I mentioned the part about the National Sheriffs because this issue isn't isolated to our state. It is a nationwide issue. I will tell you that in our eyes, we appreciated the work that has been put into this. And quickly, we had some of the similar concerns that the committee has voiced today. I did not provide written testimony today, as we really assumed that this was headed for a work session and that there was language salad here that needed to be addressed. And I see that with some of the confusion today. One of the very first points that we were concerned about is we felt as though striking any in that was removing our federal partners. And that was a no-go from the start. And I think that was immediately resolved to say, okay, we're not going to remove our federal partners. We cannot do that. We have a responsibility, whether this is a municipal, county, state, or federal law enforcement partners. The second piece was important to law enforcement is that there were criminal charges noted when somebody's brought into the jail. Let me be clear. Some of what I've heard today is the word salad when we're mixing civil versus detainee versus arrest. That's part of the issue here that has to be cleaned. There are no individuals being held in county jails on a civil detainer. You cannot put people in jail on civil detainers. If there's an arrest that's made, whether it's a state law or a federal law, that's what we want clarified in this. Under the previous administration in the state of Maine, we had a challenge when federal marshals brought folks in. Matter of fact, this used to happen to us with probation officers as well. They would simply call in and say, the police department's bringing this person in, a federal marshal, a state trooper or something. Could you just hold this person for us? And what happened in that case in Massachusetts was actually a lawsuit where the individual was just held for the federal marshals. A period of time went by. Local county sheriffs and correctional people called the marshals and said, what are we doing with this person? Probable cause hadn't been established. They decided to release the person. The person turned around and sued the sheriff for holding them. And so we brought this forward, and this was an ideal time for the sheriffs and the counties to get something into the statute that requires all to make sure that when an individual is brought into your jail, These safekeeper forms, admission forms, they're all called a little bit different, but it is already outlined in our standards that jails, including our regional jail, all use an admission type form. And when that admission form simply means that when you walk through the door, it says, I, the law enforcement officer and agency, request the sheriff to hold this individual on a criminal charge. It's as simple as that. And then they list out the charge. And if there's bail requests that they want, particularly when it comes to domestic violence and whatnot, they're able to list some of those things. When's the next court date? Those type of things. So I think we're headed in the right direction. I think there's a few things that need to be worked out. We do have the issue, I think Representative McIntyre brought this up earlier. One that we a little bit overlooked was the probation holds, right? So those are sometimes not always new charges. Those are technical violations. So I think we gotta wordsmith that a little bit to make sure that we don't oversee probation folks that are brought back into the jail. But again, this, from our point, does not remove federal, and you would not get the support of the sheriffs if that's the case. That's the fact. And then the second part that was very clear to us that these should be criminal charges. I have not spoken to federal agents, whether it's marshals, ICE, or other DEA or whatnot, who have said, I'm trying to bring somebody into your jail on a civil hold only. They're citing federal violations of law that are crimes. Now, a couple things did come up for us is in our statutes, it's very clear that if somebody's arrested on a state statute, there's a process that says this person must be arraigned within 48 hours. And if you run into the holidays or extended weekends or close of court, that there's a probable cause affidavit that's filled out that allows us to get a justice to review that, to say, okay, you still have enough probable cause to hold that individual. The question that we have as sheriffs is we want to make sure that the feds are following that same process, that they can't simply bring somebody in, even on a criminal charge, and have them set there beyond an X amount of period with what are we doing next. So I want you to know that no different than this group, and you folks have had your sheriffs in front of you a lot, right? To have the sheriffs come to general consensus on something that's so important, I think speaks volumes of where we are with this. We want to make sure that we're protecting the public. We want to make sure that we're not pushing any law enforcement out. I mean, this could be railroad police. It could have been could have been anybody with law enforcement authority to make an arrest and bring them in. That's the real crux of this. And so I ask that when we get this to work session, that you allow us to continue to work on a few of these. So many of the questions today I think are ideal, but some are tremendous questions. I do feel like some of the questions, it's words that we're not applying detainee versus an arrestee, a prisoner. And some of that's outlined. And I think we can fix some of that. I'm happy to take any questions that you may have.
Representative Lookner?
Thank you, Madam Chair, and thank you, Sheriff Morton. I don't have it in front of me, but when we were discussing the budget, not only in this committee, but in housing, we were shown tables about the number of residents at each jail. And one of the numbers that leapt off the page to me was that the Androscoggin County Jail is like at 122% capacity. So I know there is overcrowding in some of our jails. So that seems to me to be an issue. So I guess with that in mind, what benefit is it to the sheriffs to be required to enter into contracts with these various entities and federal, and if the statute isn't, if what we're discussing here and when we get the amendment, it's not going to necessarily change that, but why would you want to be required to enter into a contract with anybody who might want to bring a detainee to your jail?
Yeah, so I appreciate the question. So again, I think this is a little bit of word salad. This doesn't require us to enter into a contract. And if you look at Androscoggin, Penobscot County Jail, we're way over capacity. We're not able to take in federal boards because it makes no sense that I'm boarding out people at the expense of property taxpayers. You hear me say that all the time, that most of this is done by property taxpayers, to board people out of my jail only to bring in federal holds. So we don't do that. There are some jails that have the capacity, and so they have the ability to do that. Representative, I don't think this law has anything to do with holding individuals as part of a contract. As a matter of fact, we want to make sure that if you have capacity and you are able to contract, that you should be able to do that. This law does not impact our ability to do that, and that those individuals will be held just like anybody else on a criminal charge. I hope that answers your question.
Follow-up question?
I thank you. And I guess just as a follow-up, it would seem like it would be to the jail's benefit if you had a little bit of discretion about who you want to take and for what reasons.
So absolutely, Representative. So I'm a prime example, right? So Penobscot County Jail's in the news for a decade of being extremely overcrowded. We will still take any federal arrest, state or county arrest in the middle of the night in the best interest of public safety. Even if it's in the middle of the night and I'm extremely crowded, we owe it to public safety to do that. Our agreement with the feds or anybody else is that you will move them out of our facility within a few days. Quite frankly, they usually do it within a day. They're doing that. But in the middle of the night, if there's an urgent situation when you have somebody that needs to be placed in custody, all jails should have the opportunity to take that person in. It really becomes a housing issue after that. And there are jails that have capacity, a few county jails, I think 3 or 4, that have the capacity to bring folks in. It is important. It does help take the burden off from taxpayers. If they're going, rather than build another federal jail in our state, allow the counties to do that, take in some revenue that offsets property tax payers. Really different from this bill. This bill has nothing to do with the contracts and the boarding of federal prisoners charged with criminal offenses.
Representative Ardell?
Thank you, Madam Chair, and thank you, Sheriff Morton.
You're welcome.
To what extent do Maine County jails house aliens charged with administrative violations?
So that's not occurring. So, and again, this is where we want to make sure that that's being documented, that they're signing them in to say, I'm actually signing you in under a criminal offense, right? And so one of the challenges, if you can imagine, for a correctional officer in any of these facilities, this is why we're working with folks to make sure that we're protecting the counties as well. Our correctional folks are probably as versed in state law as many of the arresting agencies themselves. When they come in, the county jails do regional booking processes, which means they're doing the fingerprints, which comes with a sequence number of each charge. And often a corrections officer will tell you, this is the statute, it's a felony or a misdemeanor, and here's the sequence number. They're well versed in those state laws. They wouldn't be in a federal law situation, right? And so it's critical that when you're filling out whatever we call this, an affidavit, a safekeeping form, a booking form, when you're signing that in as a law enforcement officer, you're swearing to the sheriff that I've established probable cause to make an arrest, and I'm asking the sheriff to hold that person for that.
Well, I think, I'm a kind of simple solutions kind of guy. For a booking form where there is a arresting officer affidavit of probable cause, and I'm pretty sure there's federal sequence numbers that are used sort of in place of state violations for jail bookings. But could any concern of lack of probable cause for a detention on the responsibility, on the backs of the county jails or the sheriffs, could that be completely alleviated by just a line on the form for federal administrative violations where, an officer could just sign and check the box and say, this arrest is based upon a finding of probable cause?
I think we're saying the same thing. Yeah. So I think.
But what I'm talking about specifically is not, I know it exists and I've signed it several times for criminal violations, but for administrative arrests as well, because they are made on a basis of probable cause. So as long as that is documented, essentially the jails are off the hook, because the jails, I'm sure the jails don't make a determination of probable cause. The arresting officer does. So all they have to do is make that statement. Would that satisfy the need to sort of make that assertion?
Yeah, I think that's what we're saying because that form already kind of has it on there.
Right.
I mean, and this is another part because it is in standard already under admissions E1, that this would allow maybe a standardized part to capture that top part that
Right.
actually captures some of that language. I think this is a protection for the jail. I think it's a protection for individuals to make sure that that's being done. And I just think those, where we call them civil or detainee, there's still a crime that's occurred, right? And if that officer, federal, state, county, municipal officer is establishing that they have probable cause to say that this is a criminal violation, whatever you call it, the federal system, they may be calling it administrative, but it's still a crime.
Right.
Yeah.
And that's where I think, not to
Yeah.
cut you off, but I think when you talked about using the correct terminology and sort of the word salad is that what we're discussing when if it comes to specifically immigration violations, they're not civil violations. They are administrative violations.
Mhm.
And I think that's where sometimes the language, people without a deeper understanding of this tend to use the wrong terms.
Yeah.
But I mean, simply like, would the county jails accept a separate line with a separate assertion that says this administrative arrest is a result of a finding of probable cause?
I think that certainly should be part of this discussion and making sure that we understand what that means. Again, we don't live in the federal world.
Right.
And so perhaps reaching out to our federal partners to say, what is this? What, if you're going to sign that and say that, are we saying the same thing? And that's what's important to us.
I think that's a great idea and would probably alleviate the majority of any concerns that may be here. Thank you.
Yeah.
Representative McIntyre?
Thank you, Madam Chair. Thank you, Sheriff Morton, for being here. Are you able to address the question that I tendered to the bill sponsor about potential fiscal implications?
Yeah, so yes, thank you for the questions. It is an important question. So this, as we look at this bill, has zero to do with those counties that actually board inmates. So it doesn't prohibit you from boarding in inmates, which becomes a revenue source to help relieve the incredible budgets and not put those on to property taxpayers. So it doesn't impact that at all. So we're not concerned about that part. We're not seeing individuals flooding our jails, particularly, I'm in Bangor, right? And as I mentioned before, we talk about having a crowded jail. We're just simply not seeing that. The federal partners, DEA, marshals, often look at those facilities that have capacity and know that they can reach out to those facilities. I don't think this is going to impact the burden or put an additional burden or take away potential revenue from any of those facilities.
A follow-up question?
One quick follow-up, and
Yes.
that's revenue source without the previously mentioned contract situation, right? It's just availability that's reimbursed.
That's correct.
Thank you.
And so in the case for us, a representative is, I don't have a contract with the federal marshals or ICE or anyone. But if we're holding individuals for short periods of time, because I still believe we have a responsibility to taking folks in under criminal charges, and we can bill for those few days. And I don't have a contract. They're going to pay us for holding them there if it's 2 days, 5 days, or whatever the case may be. So, and that's currently in process. That currently happens.
Representative Perkins?
Thank you, Madam Chair. Thank you, Sheriff. Does every jail use the exact same intake form, or are they individual to the facility?
Yeah, so that's a great point. And I think I'm going to tell you that they're very close. And so just this morning, it just happens to be that my jail administrator is the chair of the Jail Administrator Association. We're going to ask that those forms come in and look at those. I'm certain that sign in at the very top, the rest of it's going to look probably different, right? The charge, where the charge goes, where your bail goes. But that first charging document, which is in our standard that says you're requiring somebody to put their name as the officer who's bringing them in, what agency is requesting that this person be held. That will be the important part. And does it make sense that part standardized? Probably does.
So follow up.
Please.
So is there anything that stops you right now as the head of that jail from just adding that to your form? That the checkbox that Representative Ardell mentioned?
No, no, because it's a standard and I think just tweaking the language or ensuring that it's there certainly helps that.
So this feasibly could be done without legislation, just by adding that, by the jail administrators making a decision to add that to the form.
Possibly. So, yeah, possibly. I think it's critical that the change to the law as originally drafted does not exclude any and outside agencies, federal, those that we didn't necessarily identify, and that we are concerned because this protects the counties to make sure that that language is right. It may be able to be done through a standard, but the standard's a standard versus actual law, right? And so we still also have to that representative, the issue that we have to address with probation holds. That this wasn't even really thought of in this bill, but it's something that we brought up in judiciary because some of those probationers coming into the county jail is an expense to the county. Last year, my good friend, Representative McIntyre, brought this in front of judiciary to try to address probation holds coming into the jail because there's a cost associated with that. They're coming through the door today, and those aren't new arrests.
Right, but the current law states any other law enforcement agency. That seems pretty all encompassing to me. And I do have a question here, Madam Chair. So if
Okay.
this been a problem, how has this been able to exist since 1964 if this has been an issue?
So the issue really came forward a few years back. Governor LePage was in office and it really had more to do with federal marshals. I think most of our agency, I've been in the business for a long time, as you know, had less day-to-day involvement with ICE or Border Patrol or Border Protection. Really our federal marshals, DEA agencies in that federal arena. And the concern became, again, going back to the Massachusetts case that really brought this to our light was, we can't just simply let people say, we're going to bring them in, drop them off. We'll get that form to you later. It needs to be filled out. And so in this, we actually thought as sheriffs, I think it's very important that people are signing that document, that admission into your facility. Right now, that's not in statute. So if somebody was to argue with me, representative, to say, it's not in law, I don't need to fill this. I would like to be able to say, I'm sheriff, then don't bring them to our building. That'd be great. But where in statute does it actually say that?
So to respond to that, and I have a question, Madam Chair. Is there any other part of your intake that if they brought it in and say they didn't want to provide you with a name or anything like that, you would accept that prisoner?
No, I would say we wouldn't.
So if that was on a standard part of your intake, would it seem reasonable to you, then they would fill that out as part of the normal process and you would be able to either allow or deny entry of that or acceptance of that prisoner based on whether or not they're willing to follow your guidance on your intake form?
I think that's a fair assessment.
Thank you.
Representative Milliken.
Thank you, Madam Chair. Thank you, Sheriff Morton. I just have maybe a rookie question. The Senator Talbot Ross, when she did her presentation, Representative McIntyre asked if the bill would still allow for local law enforcement to detain people who are accused of civil infractions to county jails. What are some civil infractions that would result in arrest?
You wouldn't, I don't think he mentioned that.
Perhaps I misunderstood the question. Okay.
I don't think my opinion is he didn't ask me that question.
No, he didn't ask you. Sorry.
So-
He asked Senator Talbot Ross when she was.
Understood. So we would not have, so let me give you an example. I think this is easier for those that live in law enforcement. If you're a code enforcement officer for the city and somebody hasn't followed code, your fence isn't high enough and they brought them into the jail, we're not going to take them. That's a civil code in violation by a town. We would not take that individual. That's clearly a civil matter. And so criminal matters, we would, right? And again,
That was
I
my
think
understanding
some of
as
the
well.
issue with this is much easier for this committee and all of law enforcement. We spend all of our time in statute that's main statute. And here we're trying to address a little bit. I don't believe we have the authority, and nor should we, to be able to affect federal law from here, right? But this is a process of holding individuals and just making sure that the process is clear that it's open to all. There is a protection for the sheriffs and the counties and taxpayers that we're holding individuals and the individuals themselves that are being brought into those facilities.
Could I follow? Would it be appropriate, Madam Chair, for me to ask Representative McIntyre if he could re-articulate the question he had asked the senator? Because I don't understand now if I missed the question or if.
That's fine. I don't mind. Thank you. I think I'm being subjected to the same word salad that everybody.
Okay.
So, I asked, would this exclude access to the jails by federal authorities under, I didn't use the word administrative, I used civil detainer? Would this exclude that? I think that was my question. I'd have to go back.
I can go back. Thank you. I'll be prepared for the work session.
Representative Lookner?
Yeah, thanks. And just briefly, I want to go back to something I think I heard you say. Did you say that if your jail accepts someone being taken in by the federal marshals, that even though you don't necessarily have a contract, they're still compensating you for that individual?
They could if they stay there a period of time. Now, to be honest, for an overnight stay on an arrest, if there's a bank robbery and they've been charged with a federal crime and marshals or FBI bring somebody in, I don't try to start counting the time that, to the minute that they're in the facility. But if they're there for days, we can bill out for that, even without a contract to those facilities. But there are several counties that have facilities that have space that allows them to enter into contracts to hold individuals. I don't believe in anything, and if Joyce lives this more than I do, he boards far more than I do, that this has any impact on that at all. And we believe, nor should it. It shouldn't prohibit us from having the ability to do that.
Representative Ardell?
Thank you, Madam Chair. I was just trying to rack my brain on what civil violations would actually result in personal detention. The only one I can think of is contempt of court. Really? I mean, but that's more of a coercive detention where the court makes a determination. I mean, I can't think of many, because civil is typically like monetary damages.
Right. And so I guess I'm with you like on contempt of court, but somebody brought up a fugitive of justice, right? So a fugitive of justice actually comes with a warrant, which you're arrested for a crime, right? So
Yeah, that's a criminal.
it has a criminal.
That is a criminal basis.
Yeah. And the other part of this, we don't believe that this affects transfers. So we had a discussion as well about transfers of individuals that are being held and they're being transferred. So if this happens all the time, right? Because the county jails are 80 and 90% pretrial individuals. We may have somebody, I just had to bring somebody back from Massachusetts who was convicted, sentenced, sent out of state to serve their sentence, but still have significant pending criminal charges in our state. That person's actually brought back to the jail and they're signed in. They're not going to be signed in as a new arrest. They're transferred on a writ of habeas corpus to come back and attend court on a pending matter. So I don't believe that this bill impacts any of those transfers when it comes to court orders, probably similar to your contempt, because that's a court, you're still going to get an order from a judge.
Not my personal contempt.
Not your personal, right? I understand. I'm with
My example.
I'm with you.
But thank you.
Should we let Sheriff Morton have a break and bring another sheriff up? Okay, a question.
Thank you, Madam Chair. I remember, in Somerset County, when they first built the jail, they had a lot of federal prisoners, which helped them pay for the jail. So it was really important. And
What's the question?
The question is, if you do not include the federal side to find out if this works, could that hinder getting the prisoners that you need in certain situations? I know we had the sex offender one for U.S. Marshals, and they brought them in with the sheriff's offices. And that could be a possibility where it could hinder something. I don't know. But if we could include them in discussion before we make this decision, it would be helpful.
Yep. So to answer the question is, again, just to recap a little bit, that's why we asked for the striking of other to be removed, so it doesn't affect federal agencies. They can still do that, right? And this doesn't affect boarding at all. If it's a boarding issue where they're holding them for board, that transfer is not impacted by this law.
So you can check with the federal and see if that's okay, if it's not gonna affect.
I think, obviously I think there's a couple of questions that have been raised. We have a couple with our friends with DOC that we need to work through. I think that will allow us to come back to work session and be prepared. I realize, the sheriffs realize this is a complex question. Folks, we had 14 of your 16 sheriffs on this call yesterday to show the importance of this bill and how it impacts our counties, impacts public safety first, and then the individuals that may be impacted. We take this very seriously, and we want to make sure that the language doesn't somehow hurt any of us in any way. And that's why I think let's pause. I think we're a lot closer than people think. And I think we got to make sure that the language is right. So it answers many of your questions here today.
Sheriff Morton, thank you very, very much.
Thank you very much. I appreciate the time.
Is there anybody else that would like to speak in favor of this? Welcome.
Thank you.
Senator BB Center, Representative Hasselfuss, and distinguished members of criminal justice. My name is Kevin Joyce. I'm the sheriff of Cumberland County. I got to tell you, when I saw the language that first came out that was sent out by Senator Talbot Ross, I was against it. Number one, because it was putting politics before public safety. But secondly, there's a monetary for some jails, including Cumberland County. I'm not going to lie to you. 33 years ago, the U.S. Marshals came to the Cumberland County Commissioners with $1 million to build a new jail and had a 20-year agreement that there would always be beds for, at that time, the U.S. Marshals. When Senator Talbot Ross and Mike from ACLU came to me, I told them point blank, I'm against it. Because of the public safety aspect, as far as we owe it to our communities to make sure that the worst of the worst, as the administration calls it, are locked up. And when they leave our custody, they go into ICE custody, because we have people from Maine now that are committing heinous crimes. And I hear people wanting to buy islands to put them on so that we can keep them away from normal society. But it was also a funding. You know, I have to look out for my property taxpayers as well. And I've had a year full of people telling me that I'm heinous and for holding people at the Cumberland County Jail. And right now, the budget will go up, and I will hear from the taxpayers, because I'm the one that's out in the community. Not so much the county commissioners, but I'll hear from the taxpayers, and I'm hearing it now, on what the county tax is going to be. We also are trying to run jails with unfunded mandates that are hamstringing us. 33 years ago, the Cumberland County Jail was funded by a two-legged stool: property taxes and federal revenue. In fact, in 2006, I had a county commissioner pull me aside, and I was chief deputy at the time, and asked me if I could call the feds and have them arrest more people because they needed the revenue. And at that time, my predecessor, Mark Dion, said, look, this is like the stock market. You know, 1 minute you got 125 federal inmates, the next minute you could have 30. So you can't rely on them. But a lot of jails have. Then bring in the Board of Corrections, and that debacle, that created the three-legged stool. So now we come to the state for whatever we need, and honestly, we never really get what we really need. Yet we have to meet these mandates. I have no interest whatsoever in holding, whatever you want to call it, ICE, civil infractions or administrative infractions. In essence, people that forgot to sound their name on a certain line or misspelled their name, That's for ICE to take care of and deal with it. That is not, in my opinion, a public safety issue. In fact, I will take a limb here and say that sometimes I think our own state and our own counties utilize the jail a little bit more than what they were built for. Frankly, the jails were to make sure people show up in court and to protect public safety. But we're using them for mental illness and all this other stuff and thinking that somehow miraculously, whether they're with us 24 hours or 25 days, somehow we fix them. So I'll put it up front. Until January 23rd of 2026, I held ICE inmates, and they were the worst of the worst. And it wasn't because of anything special other than speaking to ICE and saying, I have no interest in holding people that have made an administrative violation. Just like I have no interest in having somebody bring in a problem speeder for 25 miles an hour of the speed limit. You can't do that. And I'm not going to let them in. And I equate that ICE thing as well. We've worked with ICE. If somebody gets out of serving a sentence, yeah, I'll convert them over to ICE because they've got a detainer and they've committed a crime. And that was what I was told a year and a half ago by the Border Czar, that they were trying to target those folks that are committing crimes. I'm 100% behind it. So on January 2023, they took 50 people that were the worst of the worst. They were medium security or high security. A third of them from Maine. The other 2/3 were from New England. The people that did the administrative violations, they were taken somewhere else. I don't know. But I wouldn't take them, and they were okay with it. Let's face it, ICE needs me more than I need ICE, right? I mean, we have the bed space. But the reason that I was against this, and I, again, credit Senator Talbot Ross and Mike from ACLU, is this. We have a federal court in Portland. There's a federal court in Bangor. It makes no sense to ban them from housing their inmates 4 miles away and make them transport their inmates out of New Hampshire, whatever. So, yeah, I'm a little passionate about this because it's kind of right and wrong. You know, I want to do with the right thing. You know, we're elected for public safety purposes. I want to work with Senator Talbot Ross and the ACLU and the MSA to come into something that we can service our federal partners, but also do it in the right way that we know it. I'm not going to stand here, even though I've had about 15 years experience 20 years ago with the old immigration naturalization. Enough to be scary to know that they have the ability to lock people up or detain people for administrative stuff. You know, they can figure that out. But I believe the Cumberland County Jail and all the other jails, if they have, whether it's a U.S. Marshal, heinous criminal, or an ICE heinous criminal, or a local heinous criminal, they need to have access to the jail. We wouldn't lock up a civil, as mentioned by Representative McIntyre. I understood it correctly. Would we ever lock up a civil person, you know, for a state? The only one we can think of is a judge ordered, not following the laws with the judge. We would never lock up somebody going 25 miles an hour over a speed limit. You know, I would stand here and say that it's a misdemeanor crime for going 30 over. And I've heard officers say, yeah, I hooked up a soccer mom, or I arrested her for going 31 miles an hour with the speed limit. I'm not sure what that accomplished when you could have summoned the same thing. So I'm really kind of stuck on, I have no interest in holding administrative people, but Maine has got to keep in mind that we got some really bad people. I had a murderer in my jail that did his sentence in Boston and was brought up to the Cumberland County Jail to be housed there pending deportation. He committed murder. I think he should be deported. I had child sex offenders and other people, and I think they should be deported. So this bill allows us to work and not throw the baby out with the bathwater. And I think the original bill was going to do that. So I'll answer any questions.
This is more for Will. Can we just get any data you can find on anything that we just talked about? Especially around the civil stuff, if there's been any that has been reported? Thanks.
Representative Look.
Yeah, thanks, Madam Chair. Thanks, Sheriff Joyce. And know you've had quite a bit of public pressure in the last 8 months or so. I guess for the work session, and I took an interest to this, I was looking at the Cumberland County website, which really shows, like the INS detainers and so forth and so on. And I'd be interested just to see some data for the work session. And maybe this is what Rep. Abdi was asking for, concerning which detainers or administrative detainees have been charged with crimes. Or maybe not specific individuals, but just that, break it down if you can, the number of people and then who has actually been charged with crime.
I will try. Again, those individuals that were picked up on the street because of some administrative issue, didn't commit a crime, were never brought to my jail. The detainers were the individuals that were serving a sentence for assault, aggravated assault, or whatever. They served their sentence and then they were in my jail and there was a detainer put on them. So when they were released, I didn't release them. I released them into the hands of ICE. Now, I will tell you again, because I didn't want my people being considered ICE, I would let ICE know, you want this guy? He's going to be released 2 days from now. You better come in and arrest him because we're not going to hold him if you're not here. And we had an agreement that they worked through that. So this is the complex thing is I wasn't getting the individuals that, but for some administrative violation, they were coming to the jail. Now, several years ago, there was an issue with that. And I worked with ICE and said, I have no interest in that. You can find somebody else that wants to take those, but I will take the criminals. So I'll get you some information. I'm not sure it's going to be what you want. So
That'd be helpful. Thanks.
Are there any other questions for the sheriff? Seeing none, thank you very
thank you.
much.
Appreciate it.
Welcome.
Thank you.
Senator Beebe Center, Representative Hassenfuss, distinguished members of the committee. Good morning. My name is Michael Cabetta, and I'm Policy Director for the ACLU of Maine. It's not every day that I get to stand before you and thank the sheriffs for their partnership, for being wonderful people to work with. Sheriffs Joyce and Morton have been exactly that. My testimony is about the original bill language, and rather than rewrite it, I've spent the last few days trying to develop new language that the sheriffs can get behind. There were a few representatives here, Representatives Lookner, Abdi, Ardell, and LaJoy, who weren't able to hear about the legislative history that led to this law being put in place in 1964. So I'll cover that briefly. Now, the emergency statute that underlies the sentence in Section 1502 of Title 25 was enacted in response to a situation in Rockland, which historically had received individuals arrested by state police and neighboring cities and towns at no cost. Rockland decided to discontinue that practice. In response, the Attorney General's office issued a legal opinion explaining that because a municipality like Rockland is a subdivision of the state, it cannot refuse to accept state or other municipalities' arrestees. The 1964 statute was enacted to codify that opinion. But the Attorney General's rationale does not apply to people arrested by federal law enforcement for civil offenses. there's nothing in the Attorney General's opinion about federal arrestees. The legislative history makes clear that the legislature enacted this emergency legislation to permit necessary cooperation between state, local, and county law enforcement regarding the holding of criminal detainees. So the original language of this bill tries to align Section 1502 with the original intent of the Maine State Legislature. Now, during the very rich discussion that preceded my testimony, I think there's been some misunderstanding about both what the compromise language that we're working on and what the original language would mandate. Senator Searway asked a very perceptive question about what's the impact of leaving out other. And the impact would be in the original language that there would be a mandate on jails to accept anyone with a criminal charge. But jails and counties have discretion about accepting anyone else. That includes federal detainees. That includes federal arrestees who might not have been charged with a crime. The people that Representative Ardell was describing as being suspected of administrative violations, which are civil violations almost entirely. And so what this bill does is it narrows the mandate and leaves the rest up to local discretion, up to the discretion of sheriffs and counties. And so if a county decided to fully cooperate with the federal government in all arrestees, everyone arrested, regardless of the type of charge, there's nothing in this bill, and there's nothing in the compromise language that would prohibit that. The only thing that this bill and the compromise language would do is make the mandate clear. The mandate being, if someone is brought to you by county, state, and other municipal police, and by the federal government, and they have a charge against them that's criminal, and that charge supported by probable cause, then you have no choice. You're mandated to accept that person. As for everyone else, the county can make its own decision based on its resources, based on the wishes of its residents, of its county commissioners. As Sheriff Morton said, we're going to take the next couple of weeks to come up with language that satisfies everyone. And we're not entirely happy with this new concept that we've landed on, but we do still support it. And that's because we think that it would align the statute better with original intent. And it would also give the localities an important choice about how to use their jails. Our perspective is that jails should be for people charged with crimes. But if a locality decided to depart from that and say, no, we want to house people not charged with crimes as well, well, the original bill and I think the compromise language would leave that choice up for the locality. And so with that, I thank you for your time and attention, and I'm happy to try to answer any questions.
Thank you. Representative Milliken?
Thank you, Madam Chair. Thank you, Attorney Cabedi. You look different than Alicia Milnick, who's been before us recently to read your testimony. My question, I guess, is then if given the opportunity to make their own decisions, the counties that received federal law enforcement holds for civil violations would be open to the liability that is the concern here. You know what I mean? Does that question make sense?
Yeah.
Okay.
Yeah. Yeah, Sheriff Morton and Sheriff Joyce touched on that. So people who are illegally arrested, whether it's for civil or criminal reasons, can sue whoever arrests them and whoever holds them. And so liability extends both to criminal arrestees and to civil arrestees. And a locality can, and we would advise should, look very carefully at whether they want to risk that kind of liability in exchange for whatever they're getting for arresting everyone, holding everyone in their jail. And
Are there other questions for the director? Yes, Representative Ardell?
Thank you, Madam Chair, and thank you, Mr. Gabiri. Just as a clarification on one of your last statements, isn't it true that practically anyone can initiate a civil matter against anyone else? Is there any bar to that?
You can sue anyone you want. I think that's what you're going for, but you can't arrest anyone you want.
Well, no, clearly, but that's no. We're talking about civil matters.
Yes,
But
yeah.
my real question was, going through the 1964 law and the reason behind that with Rockland and the history behind that, isn't it true that the 1964 law was designed to keep jails from making the decisions about detentions, about who they detained and who they didn't? Is that fair to say?
Yeah, that's fair.
So isn't it true that the legislation before us, or whatever version, we're looking at with probably the final language up in the air right now that none of us have seen, isn't it true that this legislation, at least the language before us, does exactly that? It creates a situation where the county jails can make their own decisions as to who they detain and who they do not detain?
Well, so the original language, the language in current statute, is susceptible to misinterpretation. It can easily be interpreted in an overbroad manner to encompass everything the federal government does, and maybe Canadian law enforcement as well. Canadian law enforcement are other law enforcement. What if a law enforcement officer from Chile came to Maine, arrested you, took you to Penobscot County Jail and dropped you off? Section 1502 might say, and that is, I think, a reading of other law enforcement. If you're a cop from somewhere, if you're a law enforcement officer from somewhere, arrests Representative Ardell, takes them to a jail, 1502 obligates that jail to accept you.
I think it's pretty fair to say that example is quite ridiculous and beyond the scope
I
of
agree.
any standard
agree.
law enforcement activity.
I agree that would be ridiculous. And that's why this bill is necessary. We need to clarify this language that's very susceptible to an overbroad interpretation.
I disagree. I think the language is very clear, but thank you.
Point of order.
Excuse me. Do you have a question, Representative Hassenfuss?
Yes, I do actually. Thank you. And Mr. Cabete, I think you sort of got at that, but I'm reading this. The term arrested, I think we've been talking a lot about word salad. The current law, my understanding says any law enforcement agency, regardless of where they are, who they are, where they come from, if they arrest somebody, it doesn't define what arrest is. I think what we're trying to get at is to say, if you arrest somebody on a criminal violation, I think is where what I hear from the testimony is where they're trying to head. At that point, then the jail may have to make it available. But
Do you have a question?
yes, so the arrested language in the current statute, does that make clear that it has to be for a criminal violation, or could it be for any violation, perhaps of civil maritime law or what have you? And does it leave an ambiguity where the jails are sort of caught in this conundrum of the law says we have to, practical circumstances say that we shouldn't? Do we have the discretion to make that decision? Like, do jails currently have that discretion?
That's a great question, Representative Hassenfuss. So the statute doesn't make clear what the basis of the arrest has to be. And since 1964, and given our current world, it's possible to arrest someone if you are a certain type of law enforcement officer for a non-criminal violation. And we don't think the 1964 legislature wanted jails to be available, mandated that jails be available for non-criminal arrests.
Thank you.
Yeah.
Representative Lookner?
Thank you, Madam Chair. Thanks, Mr. Cabete. So since 1964, would it be fair to say that there's been a drastic expansion for the population and the eligible, I guess, uses of county jails, and therefore might it be appropriate to revisit this now because we're using county jails for so many purposes they couldn't foresee in 1964, and that we've drastically increased their uses for various things? Would that be a fair statement?
Yeah, I think that's undeniable.
Are there any other questions for the director? Seeing none, thank you very much.
Thank you all.
Is there anybody else that would like to speak in favor of this legislation? Is there anyone that would like to speak against this legislation? Welcome.
Thank you, Senator. Senator Beebe Center, Representative Hassenfuss, and distinguished members of the Criminal Justice and Public Safety Committee. My name is Jill O'Brien, and I'm the Director of Government Affairs for the Department of Corrections.
Thank you.
I'm testifying today in opposition to LD 2058, an act to require municipal and county jails to be available at all times for detention of persons arrested on criminal charges by Maine law enforcement officers, as proposed to be amended by the sponsor. The proposed amendment, which Senator Talbot Ross discussed, would include the language that someone must be arrested on criminal charges based on probable cause. This would make it so that instead of county jails having to be available for holding anyone arrested by law enforcement, county jails will only be required to hold individuals on criminal charges and supported by probable cause. This would mean that county jails would not have to accept individuals arrested for violating probation, as Sheriff Morton noted. Many probation violations are not also charged as new criminal conduct. So jails would not be required to hold these individuals because they are not being held on criminal charges and supported by probable cause. This change would mean that someone from northern or western Maine who is arrested for a probation violation there would have to be taken to a state correctional facility, Wyndham or Warren, rather than staying at the local jail. The person would have to be transported back and forth to court from the state correctional facility for an initial appearance on the probation revocation motion and for further probation proceedings. This change would be disruptive to the lives of those individuals facing probation violations and would burden the courts, the department's probation system, and the department's correctional facilities. It's unclear what fiscal impact this would be on the department's budget. The bill also potentially appears to relieve county jails from holding anyone found incompetent to stand trial or not criminally responsible, as they would no longer be facing criminal charges once those charges are dismissed. There is insufficient space in the 30-bed intensive mental health unit at Maine State Prison for those individuals. And while the Department of Health and Human Services works to accept some of those individuals at Riverview Psychiatric Hospital or Dorothea Dick Psychiatric Center, this bill could force immediate transfer of individuals found incompetent or not criminally responsible to one of those facilities or to an emergency room from a county jail without ensuring an available bed or appropriate mental health and medical treatment planning. Thus, I urge that you vote ought not to pass on LD 2058. I'm happy to answer any questions, and the department is very willing to work with the sponsor and other stakeholders on a potential amendment. Thank you.
Are there any questions for Mr. Bryan? Yes, Representative Milliken.
Thank you, Madam Chair. Thank you, Attorney O'Brien. Could probation violations not be transported to Charleston as well? Most likely it would not be Charleston because of the level of residents at Charleston, but potentially. Thank you.
Are there other questions for Mr. Yes. Representative Nutting.
Thank you, Madam Chair. Thank you, Ms. O'Brien. In your testimony, you said that the change, which is the location of where someone is held once they're detained, would be disruptive to the lives of those individuals because they might have to be moved miles away. Do you have any idea what would happen to someone who's detained by ICE or Border Patrol in Calais, Maine, if they needed to be moved to New Hampshire further away? Would that be disruptive as well?
It would, Representative. What I'm referring to here is probation violators in particular.
I understand. Thank you.
Representative Lookner.
Thanks, Madam Chair, and thanks, Ms. O'Brien. So I'm just, this legislature has given you the authority to hold people incompetent to stand trial for various mental health acuity issues that Riverview came to us, and you were, I don't know if you were a part of that whole thing that we've had in the last couple sessions, and basically begged us to say, let us use the jail, let us use the prison specifically. I didn't hear much about jails, but let us use the prison to keep people incompetent to stand trial because you have such a great, I don't know if great's the appropriate word, but you have a really comprehensive mental health unit where people can access the type of treatment they might be need so that they could be restored to competency. So I guess this just sort of seems like during that whole discussion, we were, and I'm getting to a question, during that discussion, a lot of it is like, well, shouldn't we just be expanding Riverview to hold those people if they haven't been charged with crimes or incompetent to stand trial and they need treatment? So are we now sort of arguing that jails are the appropriate place for people with that level of mental acuity crisis?
Thank you, Representative. The department does not believe that someone found incompetent to stand trial should be in county jail. They need restoration services, as you referred to, and as you referred to, there is an agreement and a statute that allows DHHS to ask the Department of Corrections to house someone at the intensive mental health unit if they present a danger to staff or others at a place like Riverview. My point in bringing up those incompetent to stand trial individuals is that I want this committee to think through what will happen to them if the statute allows the jails to discharge them, where they will go. And I would support a proposal by DHHS to expand their capacity at Riverview for those individuals.
Great. I look forward to next session when that comes before, maybe not this committee, but hopefully DOC will be supporting that.
Are there any other questions for Mr. Bryan? Seeing none, thank you very much.
Thank you.
Is there anyone else that would like to speak against this legislation?
I have copies coming, so.
Okay.
Senator BB Center, Representative Hessenfuss, and esteemed members of the Joint Standing Committee on Criminal Justice and Public Safety. I am Senator Scott Searway, and I represent the communities of Albion, Fairfield, Oakland, Waterville, and Winslow, which together make up District 16. I am here today in strong opposition to LD 2058, an act to require municipal and county jails to be able to, at all times, for detention persons arrested on criminal charges by Maine law enforcement officers. While I had a testimony prepared with many concerns with the bill, I now hear there is an amendment that makes many substantive changes to the original bill. However, I have not seen this amendment. How can anyone testify for or against this bill when we do not even have the language we are discussing before us? Since this sponsor's amendment has not been published and makes many changes, I am forced to reserve my comments regarding the pending language for the work session. If conversations are still being had among the stakeholders, including federal agencies, hopefully, I would recommend we vote ought not to pass, which would allow the stakeholders to meet and bring forth a better prepared bill in the next legislature. Thank you for your time, and I'm happy to take any questions.
Are there any questions for Senator Searway? Yes, Representative Milliken.
Thank you, Madam Chair. Thank you, Senator Searway. As your testimony here says you're opposed to the bill, but also that you can't formulate whether or not you're opposed to the bill because we don't have the language before us. So are you opposed to the bill or are you opposed to the process?
Well, I'm opposed to what was given to us before and right now, but we don't even see the change. So the problem is it was never published or anything for anybody to come and speak on it for opposed or for it. So that, you know, we had very little people here because it really doesn't clarify that. So it wouldn't be fair to our community and our state
So,
to even
but
have this.
To clarify, presently,
voted
you're
on.
not sure how you feel about the bill because we don't
That's
have the
right.
draft in front. Okay,
That's right.
thank you.
Are there any other questions for Senator Serwin? Seeing none, thank you very much.
Thank you.
Is there anyone else that would like to speak against this bill? Is there still no one on? This? Is there anyone that would like to speak neither for nor against this bill? Seeing none, we will close the public hearing on this bill. Yeah, yes, Representative Nutty?
Thank you, Madam Chair. Can I just encourage the people who are working on the amendment to get it to us before we sit in our seats for the next work session? Very hard, particularly with a bill that has so much language to what I expect this bill to be. It's hard to sit and decide while you're reading it and while people are talking. It would be really helpful to have that maybe 24 hours before the work session. Thank you.
Representative Ardell?
Thank you, Madam Chair. I'd just like to sort of echo Representative Nutting's concern. I think if there is substantive changes in the legislation before us, it might be wise to have another format more like a public hearing than a work session. And the reason is it's very difficult to have a work session on language that really no one around this horseshoe has even seen yet.
Okay.
And I think it would be important for the public to be able to, you know, and professionals, you know, in government to make commentary on that.
Okay, we'll figure it out. Yes.
Thank you, Madam Chair. This is a new guy question. Previous individual giving testimony said they'd have it done in a couple of weeks. Do we even have that latitude with the timelines that we're up against? We do not.
Well, it's, Will, do you want to come up?
Talk about it. I mean,
Okay. Do you want
do
to?
it right now
Yeah.
or we can do it here today?
Well, do you want to come up? The other thing we're going to do is we're going to switch LD 2090 and LD 2157. The person presenting is only here till 11:30. So we're going to switch the order of those two bills.
May I respond to McIntyre? May I respond to Rebecca?
Representative Hassenfest, do you have a comment?
Yeah, I think that is a well-positioned question, and I would encourage those individuals, the stakeholders on this, to try to get that amendment back to us as soon as possible so that we can then schedule it. And what we will try to do is we'll try to wait until we have that amendment before we schedule the work session. But please understand that we are in a time crunch, and you know, as expeditiously as possible is what we're requesting that amendment to come back as.
Just the person who's,
Yes, it is.
Okay.
I will introduce
okay.
Kenny Sauer. Well, yes, of course.
What is he an expert
Yeah.
So will you be introducing 2157 for work session? Okay.
Okay, Will Two, Legislative Analyst for the Criminal Justice and Public Safety Committee. So we're moving forward to LD 2157. This is an act to prohibit the unauthorized use of drones on or over the premises of correctional facilities and jails. We have Mr. Walden here with us today. He is here on behalf of the Small UAV Coalition, who provided the committee with testimony regarding some of our discussions about preemption at the committee's work session last week. Representative Lookner asked for somebody to be present from the Small UAV Coalition to expand on some preemption issues for the committee. So I reached out to Mr. Walden and requested his presence. He does have a hard stop at 11:30 today. Looks like it's around 11:15 right now, so not a lot of time, but hopefully we can get those questions answered within the short amount of time that we have today. There's also been an amendment provided to the committee. This was emailed last night at the end of our work session last week. Representative Hasenfuss requested a committee amendment detailing some mens rea requirements and a tiered system about somebody who has previously violated the unauthorized use of a drone over the correctional facilities. The language here today, I don't think it's too much at the preemption issue for Mr. Walden's concerns. So if it's okay with the chairs, if there are specific questions for Mr. Walden based off of the preemption issues, then I would kindly direct the chairs to ask those questions now so that he may go about his meeting at 11:30.
Okay.
And sorry, Representative Lookner, sorry, you walked out of the room as I was introducing. This is Mr. Walden from the Small UAV Coalition. At the last work session, you requested somebody be here to discuss a little bit more about preemption issues. He has a hard stop at 11:30, so any questions, hopefully we can discuss those first and then move on to additional conversations. So I would open it back to the committee.
Okay. So, should we have him present?
You can ask if there are specific questions from certain representatives, we can go by that, or if you would ask for a broad overview, I think that's up to the chairs.
Want to let him go? Okay. Mr. Walden,
Yes,
would you please share your information with us?
certainly, certainly. And thank you for inviting me to testify. I served as chief counsel of the Federal Aviation Administration a long time ago when the presidents were Reagan and Bush 41. I've been teaching aviation law since 1998, and our testimony that the proposed prohibition on an overflight without engaging in any other conduct would be preempted because Congress, under its Commerce Clause authority, has given the FAA plenary authority to regulate aircraft in airspace, and drones are aircraft. We have no concern whatsoever about penalizing a drone operator who is engaged in misconduct, such as trying to aid a prisoner in escape, dropping contraband, making contact with someone. But the simple overflight is something that's regulated by the FAA. And I would add that our members, Amazon, Walmart, Wing, which is part of Alphabet, and Verizon, when they operate their drones for inspection, for package delivery, they have no concern. There's not any interest in disturbing the conduct of correctional facilities and jails. I would say, and thank you if you put an intentionally and knowing amendment in there, that is helpful to us, because some jails are, unlike prisons that might be in a rural community and a drone operator would know that's where the prison is. There are, I assume in Maine, there are some jails that are in public buildings that a drone would not even be able to see when flying over to deliver a package. Thank you.
Are there any questions for Mr. Walden? Representative Hasenfuss?
Mr. Wallen, you said that the Congress has, legislated within this area. Is that only above 400 feet, or is that below 400 feet as well?
It's down to the ground. But Chair Hasenfuss, this does not displace the Maine's authority to police misconduct at any altitude. If you have an invasion of privacy statute, that a drone could invade privacy at 500 feet or at 50 feet. But if there is, but the FAA does have jurisdiction over the airspace down to the ground.
Yeah, and I read this as specifically saying no-fly zone over prisons? I mean, where it's just a straight ban of navigating a drone in that geographical area, would that be preempted?
Yes, it's our view that, and this is in the FAA guidance that was issued most recently in 2023, that flight paths, flight altitudes are up to the plenary authority of the FAA to regulate. So we've taken the same position in other states with other bills that deal with flights over schools, flights over critical infrastructure. Our response is the same. If it's a simple flight that does not interfere or impede with any operations, that is something that it's up to the FAA to say whether it's good or bad. And the FAA has authorized drones to fly under 400 feet in the national airspace.
Yeah. So let me just follow up with one other question, reading the language of the amendment. So if the state were to say it is a crime to intentionally or knowingly fly a drone over the premises of a correctional facility or jail at or below a height of 400 feet above the ground, would that clause be preempted by federal law?
Yes.
Thank
It is an improvement. It is an improvement. In terms of, our members going to be arrested for flying over a correctional facility, and they have to then come in and say, well, we didn't know it was. We'd rather not be in a situation where members are thinking, well, we may be violating the law when we don't really know. We know where they're, and so it's an improvement, but there's still a preemption concern.
Representative Lookner.
Thank you, Madam Chair, and thank you, Mr. Walden, for joining us today. I'm not really an expert on drones, but I guess my question is this 400 feet thing with if a drone operator had sort of an advanced camera and like if the concern were privacy, would it make a big difference if we changed, at 400 feet, you can pretty much see as much as you would see at 50 feet with the right equipment. Is that correct?
Yes. And if you were to draft an amendment that says a drone cannot capture an image of the inside of a prison, that again is conduct that is within your authority. It's the overflight without anything more that is up to the FAA to authorize.
Thank you.
Are there other questions for Mr. Walden? Seeing none, thank you very much.
Well, again, thank you again for the opportunity to speak with you. And if there are any other further questions, please direct them to us. Thank you.
Thank you. Yes, Representative Nutting.
Thank you, Madam Chair. So now the question is whether or not in current law, we prohibit people from dropping contraband into a prison or into a jail, or taking photographs for some reason within a jail. We just heard from him. All the rest of it is preempted. So can we have Ms. O'Reilly join us again and maybe tell us what is left that we should or can try to do with this legislation to help jails and prisons, or is there nothing?
Thank you, Representative. Jill O'Brien, Director of Government Affairs for the Department of Correction. I don't believe that this amendment in front of you is preempted below 400 feet. And the reason that I don't believe that is that in December of last year, the federal government passed the Safer Skies Act as part of the defense budget. And they expressly give the states jurisdiction to, with respect to unmanned aerial vehicles, to take action to protect the security and protect people's facilities or assets necessary to mitigate a credible threat that an unmanned aircraft system or unmanned aircraft poses to the safety or security of people, facilities, and assets. A venue or set of venues used for large-scale public gatherings or events, critical infrastructure, or correctional facilities. And this is information I've provided to Will a few weeks ago in anticipation of the first work session. So I think the preemption issue is debatable at best. And we already have a rule outlawing them over Baxter State Park. New Hampshire, Tennessee, and Arkansas have all passed these laws. So I think that it is not a settled question at best for.
Thank you. I'm done for now.
Representative. Yes, Mr. Walden.
Yeah, I'm sorry. I would just say, yes, the Safer Skies Act was in the NDAA that was passed, and we acknowledge that law. We have no problem with that law. And that, again, is Congress determining to give state authorities over counter UAS detection and mitigation. That's different than flying overflight.
Representative Perkins, did you have a question?
I didn't have a question. I had a comment in response to Representative Nutting, and I respect the professional expertise of the gentleman with the coalition, but I also agree with our DOC colleague here that I think there's now 13 states that have passed similar legislation. So I would say that since 13 states have passed this legislation or very similar legislation, I would agree that that is a debatable point.
Representative Lookner?
Yeah, thanks, Madam Chair. And Mr. Walden, so in your last statement, you said, I was a little bit confused over what Congress delegates to the states as far as how unmanned, how drones can be used, because it got a little muddled there. So can you just restate that more clearly?
Yes, the Safer Skies Act authorizes state and local governments to engage in counter UAS detection and mitigation based on a credible threat to the safety or security of the critical infrastructure, which would be which would include a correctional institution.
So the argument then is that just a flyover by a UAS doesn't constitute a credible threat.
That's correct. It could, but it's highly unlikely that an Amazon package delivery will serve as a credible threat. And I'm very sorry, I'm getting to my witching hour, but thank you again for the opportunity. And again, happy to provide any written or email answers in a letter or an email to your questions.
Thank you, Mr. Walden.
Okay.
Representative Perkins?
Thank you, Madam Chair. I would agree with that statement that a couple ounce package could be a credible threat. A cell phone dropped into a correctional facility could be a credible threat, a severe threat to the safety and security of that facility, how well it's run, even the security of the corrections officers and the other prisoners that are in there. The reality is, with a cell phone, they can coordinate gang activity within a facility. They can arrange for contraband from the outside, weapons, drugs, what has to be brought inside. So even if something as simple as a cell phone can be used as a way to initiate violence within a facility, I would consider that a very credible threat. And we saw, I think I mentioned in my testimony, one of the news reports, I mean, they were specifically talking about that's one of the biggest things that gets brought in as contraband. It's not the drugs themselves, it's the phones and the ways that they use to facilitate getting the drugs in. So I would consider that a small couple of ounce package a credible threat.
Ms. O'Brien, did you want to say something?
Thank you, Senator. I think step one in mitigating this credible threat is passing a law prohibiting knowing, reckless, or intentional flyovers that can be used to take photos, to surveil the rounds of staff. Very credible threat there. As Representative Perkins stated, many states are doing this. And I find it hard to believe that the Amazon drivers could not avoid the correctional facilities and jails in a knowing and non-reckless way.
Representative Milliken?
Thank you, Madam Chair. I just wanted to respond to what Representative Perkins just said, it's already a criminal offense to drop a phone off at a prison, isn't it? Or to traffic in contraband in a prison. Okay, so again, we're just stacking new criminal penalties on the same behavior, correct? Is that the intention?
Well, if you look at the amendment, there's not the same behavior, two different behaviors, but that would contribute to the same incident, but.
I guess my point is that like what I heard Mr. Walden say was that the behavior you're describing would already be covered in criminal law. And what he was describing is not a person dropping off a cell phone or any other package. It was just a simple flyover with no other, I think he was very explicit with no other intention other than to just fly over. And then can I ask Mr. Attorney O'Brien a question? Has the Maine Department of Corrections had issues with drones flying over your facilities at this point?
Yes, 2 Thursdays ago, there was a drone flying over our facilities, despite an officer specifically asking the person not to fly the drone until he could clarify whether there was authorization to do that.
Thank you.
Excuse me, please continue.
I just wanted to make sure we all are aware that this amendment does not recriminalize trafficking in contraband. That section was deleted to address the concern I believe you raised at the work session.
I guess I was just referencing that in response to what Representative Perkins just spoken about.
Representative Perkins?
Thank you, Madam Chair. I would agree with Attorney O'Brien here that this does not add two penalties under the same thing. It's two separate activities, two separate acts, even though they might be in conjunction. And again, that these specific act we're talking about now is and adding a penalty to it is part of that mitigation to the credible threat. That's part of that mitigation.
Representative Hassenfuss?
Thank you, Madam Chair. What if, this is just me thinking,
Is there a question?
yes, and we're also in a work session as well. This is just me thinking, so, what if we added in paragraph 3 that instead of it is not a defense, if we said that it is a defense to prosecution, if the individual is licensed and the overflight was unintentional, so not knowingly or intentional, flew over the facility in a direct path, to its intended final destination, and that the drone posed no credible threat to the facility, which we may need to define credible threat if it's not elsewhere defined in statute. But the thought being that instance, I think it would set this statute up, because where there is some ambiguity as to whether preemption applies or not, a good criminal defense attorney, if anybody is charged under this, is going to litigate that, ask for it to be thrown out. And if we permit a defense for unintended flyovers that pose no credible threat, I think that significantly weakens that argument from the defense attorney. That being said, the prosecution would have to show that either they intended specifically to fly over that facility, or maybe or that it did in fact pose a credible threat, which I would think taking pictures would be that, hovering around, not going in a straight path would be that, or perhaps depending on what the drone is carrying, just the mere flyover may pose a credible threat. So that's just me thinking of how we can maybe tighten up some of this legislation.
Representative Perkins?
Thank you, Madam Chair. In response to our esteemed chairman here, I think adding the mens rea, I think is a good step towards making sure that someone is wrapped up in this, someone that actually was truly active in this infraction. My problem with some of his statements was even using the drone for surveillance could be a credible threat, and it would be very hard for someone to say, yeah, I was just flying over, when in reality they were feeding live video back. to show, locations of security elements or points of exit or entry or whatever. And I think that would be an extremely difficult thing if we added that in, that we'd ever get a conviction off of this, other than actually watching somebody drop something off. And I also want to make a general comment about what the gentleman said, and it just hit me, but he talked about his clients being Amazon and all these Walmart and everything. And we operate drones in our real estate business, and I can't speak specifically because I don't work for Amazon or Walmart, but I'm pretty sure that when deliveries are made by Amazon or Walmart, there isn't some guy with a controller like we use ours directing those. My drones are capable. You put a path in there, a flight path in there, and it's all automated. And they go do their thing and they fly back with very little human intervention. So I find the argument that this would adversely affect companies like Amazon or Walmart, I find that almost a little bit laughable, because I'm pretty sure those companies can avoid, once they know where those areas are and put in their flight path, they would be able to very easily comply with this law.
Representative Lookner?
Yeah, I'm just wondering if it's already in Maine statute that it's illegal to record a correctional facility from the exterior.
Not that I know of, Representative. And certainly in the paper today, there's a photo of front of the main correctional center in the press herald.
Sorry.
Representative Ardell.
Thank you. Just to follow up that question, is there any legislation that restricts photography within the walls of the facility?
Not legislation, but legislation gives the wardens, the chief administrative officers, the authority to exclude photos and video because of the security concern of doors, entry, exits, that type of.
So that would be sort of an extension of executive rulemaking?
I believe there's a section in 34A that allows the chief administrative officers to create rules to enforce safety and policies.
Okay, thank you. So would it be,
Cameras.
so I guess would it be fair to say that restriction within the facility, whether it's from above or actually on the ground within the secured area, already exists?
The rule on paper that you can't record in a facility exists on paper. No enforcement mechanism exists for drones because we can't kick the visitor out. We can't exclude the drone.
I understand. Thank you.
Representative Milliken?
Thank you, Madam Chair. I have a question for Mr. Tu. I missed the first work session. Did you provide information to the committee about the penalties for flying a drone over Baxter State Park?
I did. It was odd because I think there was a broad statute regarding, I don't think it was specifically in statute regarding you can't fly it over Baxter Park. Baxter Park actually has its own set of rules, and I think that's authorized. I think it's somewhere in Title 12. Then there was a general law regarding, let me see if I can find it in. I don't remember if I included it in the actual bill analysis or if that was just off cuff. Okay, it is. It's a section 4 of the bill analysis. So on a state level, the Bureau of Parks and Lands State Park Policy prohibits the use of UAS in Maine state parks, historic sites, or Department of Agricultural Conservation Forestry boat launches without approval. So that was the only portion in state law that I could find. And then, so Baxter's Park Authority, I think, came from that authorization, but there's really not a lot about drones being prohibited in state law.
Yes, Ms.
Yeah,
O'Brien.
Thank you, Senator. In our testimony, we pointed out that Park Rule 5.5 imposes a $1,000 civil penalty for flying an UAV in Baxter State Park.
Madam Chair, I'd
Follow
like
up?
to request a 5-minute caucus once the conversation starts to die down, and it seems like maybe we're there. I see your eyes rolling, Representative McIntyre. Hit the back of your skull.
They're observing. I'm rolling.
We've been in this long without one.
Well, it is only our first work session.
So we'll take 5 minutes.
Are there any other questions before we go?
Democrat. I have a student observer with me. Would it be okay if I brought her caucus or prefer?
Yep, it would be.
If there's any.
Yes, it is open.
Yes, it
Thank you, Madam Chair. I would like to make a motion of ought to pass but amend the bill to remove the word recklessly from section 1A. Make the first offense a civil penalty of about $500 and all subsequent offenses Class D crimes. Did I get everything?
Yes. Okay. Yes, Representative Perkins.
Thank you, Madam Chair. I just have a comment. While I appreciate the motion does pass the bill in some form, after having talked with Attorney O'Brien, I think there's going to be a lot of issues with trying to get any kind of meaningful conviction out of an actual violation of the law if you add that civil in there and if you lower that. And so for that reason, I'm going to vote against that and instead be in favor of just accepting this amendment as proposed by DOC.
Yes.
Sorry, Rep. Milliken, what was the, for repeat offenses, what was the punishment? Was it class?
Yes, Class D of crime for all subsequent
Repeat,
offenses
okay.
after the first offense.
Okay.
Yes, Representative Booker.
Thanks, Madam Chair. My first inclination was that because the FAA and federal law sort of prohibits us from being this stringent in regulating the use of drones. My first inclination was to vote ought not to pass, but I think this is a reasonable compromise, so I'll be going along with it.
Is there any further discussion? Yes, Representative Odell. Riddell.
Thank you, Madam Chair. Just as sort of an idle question to the committee or the suggester of the motion, why skip the E? I mean, it seems to go from civil violation to a Class D crime. Why skip the E?
Please. Representative.
Is that a friendly amendment you're offering, Representative Ardell?
Merely a question.
I don't know. Good question. I think I'm going to leave it the way it is because it's what we agree to, but I appreciate the thought.
Representative Hassenfuss.
Thank you. And from my perspective, the skip in the E, the civil violation would be there for that individual who didn't really know what they were doing, knew they were flying over a prison, but didn't really know the severity of that, get the civil violation, and then they're told, you're put on notice. You know that you can't be doing this again. They do it again. I think it's fair to punish them by up to a year in prison for that crime, knowing that any subsequent crimes, their sentence probably will get closer to that maximum allowable year in prison for that. But my question for the committee, the members who made that motion for the amendment is, I do see a difference between simply flying over the premises and landing or flying from the premises. So I'm wondering if the civil violation could be only for the flyover, where if you're landing in a correctional facility or flying from a correctional facility to jump straight to the D. Because I feel like in those individuals that person knows better, knows you probably can't land a drone in a prison or fly a drone from a prison, but I can understand how somebody could be unwitting and thinking that they could fly over, at 300 feet or so in a straight path, something like that on the prison. So I asked that to those members to see if that's something that they would like to consider or not.
Do you want to change your proposal?
I'd like to leave my amendment as I stated the motion.
Okay. Yes, Senator.
On the civil violation, how much of a fine was it?
500.
Not enough.
Okay, is there any further discussion on what's been proposed? Yeah. Will, could you please?
Yes, so
read
as
the motion?
Representative Milliken stated, so we would be moving recklessly as part of a mens rea. So it would require that somebody intentionally
Senator
or
Sealy.
knowingly flies the drone over the premises, from the premises, or on a premises. So for the first attempt, or sorry, for the first act, it would be a civil violation. And Rep. Milliken, is it up to $500?
Yes.
Okay, up to $500. But if they're going to be repeat offenses, then it is going to be a Class D crime rather than a Class C crime, which is the current amendment in front of the committee from the Department of Corrections. So makes it more difficult because there's an increased mens rea requirement, lowers the first from to a civil violation, and then for repeat lowers it from C to a Class D crime.
Yes, Representative Look.
Maybe just a clarification, we're not lowering it from a Class C crime, we're creating a new Class D
Yes,
crime.
sorry, I'm just speaking from the point of the amendment that's in front of the committee. Yes, but yes, for clarification, there is no current crime. It would just be a Class D. Yes.
And it was seconded. Is there any further discussion? Yes, Senator Searway.
If you go, I don't know what your thoughts are, but I just thinking, 1,000, up to 1,000 would give some leverage to the judge of how serious it is. And I think it would be more apt to be acceptable, but I don't know.
Senator Searwood, do you plan to vote for the amendment that I've just proposed if I change the civil violation to be $1,000 penalty as opposed to
It's a
$500?
thought, I don't know. I'd have to talk to the other group, but
Looking at your Representative Perkins just stated on the mic that he would likely not support what I propose. So I'm all for having a conversation if it gets us to a unanimous vote, not a floor fight, Senator, but I'm not sure your caucus agrees with you.
anyway.
Any further
I guess-
discussion? Or are we ready to vote? Did we want to change? Okay. Are people ready to vote?
Okay. LD 2157, motion is ought to pass as amended by Representative Milliken and seconded by Representative Abdi. Representative Hassenfuss,
Yes, I'll vote for the motion.
Representative Nutting,
No.
Senator Searway,
No.
Representative, oh, I'm sorry. Representative Nutting says no and Senator Searway says no. Representative Lookner,
Yes.
Representative Lookner says yes. Representative Abdi,
Yes.
Representative Abdi says yes. Representative Perkins,
No.
Representative Perkins says no. Representative McIntyre,
No, thank you.
Representative McIntyre says no. Representative Vardell,
No.
Representative Vardell says no. Representative Bunker,
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. Representative Milliken.
Yes.
Representative Milliken says yes. Senator Beebe Center.
Yes.
Senator Beebe.
Can you change your vote?
I think so.
Now we're still in the voting.
Representative Lookner.
No.
Representative Lookner says no. So we have 6 in favor of the motion, 6 opposing the motion, and 1 absent. And the motion by all of you opposing the motion?
Yes.
As I stated earlier, my alternative is vote ought to pass as amended by the strict wording of the March 4th DOC amendment.
Are the rest of you opposing the motion? What's I almost made you center. No, okay.
Representative Lookner?
My motion is ought not to pass.
Okay. Representative Lookner says ought not to pass. So now we have 5 with Representative Perkins and 1 ought not to pass.
Are we ready to do LD 2090?
Thank you, Mr. Chair.
My pleasure.
Thank you.
All is forgiven.
Are you ready, Will?
Yes.
Okay.
So we have LD 2090. This was an act to establish a one-year probationary period for public safety dispatchers. At the end of our last work session, Representative Hasenfuss requested an amendment placing the floor for probationary periods at 6 months, but allowing it really to expand beyond that without another part of our conversations last time was whether there should be a ceiling for probationary period, public safety dispatchers. So what this does is the original bill, if you'll recall from the bill amendment, cites 3 different sections of law. It's how those probationary periods apply to municipal employees, county employees, and state employees. County and municipal employees are in some ways treated the same because the county statute refers to probationary periods under the municipal statute. So they broadly follow that statute with some exceptions for jailers. And then the state statute handles things differently because for state employees, for classified, or I always mix up the terms classified versus non-classified, but it's a minimum of 6 months as opposed to the municipal sides of things saying it cannot exceed 6 months. So they approach it differently. There's one exception in the statutes that we talked about that is in the municipal section regarding police officers. For them, it's a year after they've graduated from the Criminal Law Enforcement Academy, Maine Criminal Justice Academy. So what this statute does, or this amendment rather, I don't believe that the state statute needs to be amended because as we discussed in committee, the language from that statute says it's a minimum of 6 months. So to the extent from state public safety dispatchers, to my knowledge, they can go beyond that 6 month pursuant. They might have a collective bargaining agreement that says, no, it's 6 months. But that's ultimately between the state and the union that discussed that. Director Labby might have more information about that because I believe he has said in his testimony prior that he couldn't exceed that 6 months. So to my knowledge, that would be due to a collective bargaining agreement. That's not necessarily the state law, but perhaps I'm misunderstanding something there. So with that in mind, if we're really looking to folks that are capped at 6 months under municipalities and counties, then this is the language that I put together, checked with our office that we believe would accomplish that. So really just moves Representative Bunker's bill into just 30A. I understand putting it in Title 26 initially for labor feels fairly easy to just say this applies to everybody. But if we're looking for more specific approach, or if it doesn't already apply to state employees, then I think it's just nice for the readability of the statutes to be pertained in those actual provisions of law, but still up for debate. I don't think necessarily it was a wrong way to go about it. So again, that includes those same definitions of a public safety dispatcher. It sets the floor at 6 months and it does not provide for a ceiling. As I know, the amendment previously capped it at 12, but then there were discussions from the committee about maybe that hampers the employers in some way and perhaps the employees in other ways. But I know that's a subject of debate. That's all the information I have. Again, we have multiple folks here from the union side of things and Director Labby, as I mentioned.
Any response, any Representative Bunker?
Well, I thank folks from wading in on this and helping us with language, including staff here. I think this hits the right tone. I was concerned about in which section of what statute that would be applicable to. I think this makes a good position for it. I would like to ask Director Labby to come up and I would pose a question to him. Does this give him necessary language that allows him to go beyond 6 months by collective bargaining agreements or whatnot, or is he still capped at 6 months, period?
Welcome, please.
Pardon me. We've always been told no past 6 months. Every time we've tried to push to go beyond a 6 month probationary period for whatever reasons we have, we've always been told no. So I'm not sure if this will change that, because it just still says a minimum of 6 months, which we're meeting that threshold. So.
And so to that extent, I mean, we would need more information because the statute says that the duration of the probationary period is determined by the officer in consultation with the director or commissioner of the agency, but in no case may it be less than 6 months. So to my knowledge, statute doesn't provide the cap. I don't know if that's in department rule or where that's found or what the source of that is, but that might be helpful for clarification, because then at that point, I don't know if that's necessarily a statutory change or something that happens within the department itself.
What do we want to do? Representative Bunker?
I hesitate to wade into departmental policies and practice
Well-
on that. I was hoping that this language would allow that to go beyond with that consultation within the department. That was my goal. Yours and municipal and county likewise.
What do we do from here? Representative Hassan Fuss?
So is our impasse that there is a state law that says you may not exceed 6 months?
No, there isn't, but they won't allow us to go past it. So
Who is they?
Human Resources, I guess is what I'll say, Bureau of Human Resources. We have to get them to approve us to extend probations. And they're always the ones that come back and say, no, you're not allowed to do that.
And do you know why?
They just say no. They're not real big on the why.
Okay, well, I think that why is
Yeah.
the crux of what we
Sure.
need to find out.
It sounds like it's something I have to deal with still, which is
Well,
fine.
and it's not necessarily something that you need to deal with. Perhaps we may need to change a statute here or make a statute less ambiguous, but we need to understand why HR is saying, no, absolutely not. You cannot extend it past 6 months. And if that can be addressed, I think that solves the problem. Would you agree?
Yes.
Yeah. Okay. So then my other question is, Will, are you confident that this solves that problem?
Well, I mean, no, I think he will still face the same problem because, so part of the reason of this amendment only addressing the municipality is because in statute, it discusses for state employees that it is less than 6 months. So to me, in terms of a statutory fix, then that would need additional language for public safety dispatchers, because I don't know what their internal policy is. I don't know if they've decided between their parties because they can set that based on the language, that it's just a minimum of 6 months. So I don't know what policies that they've come up with that has prohibited him from doing that. But if that is the case, then no, this would need additional language if we're trying to touch on state employees.
Yeah. So then I guess what I'm thinking is, let's get the answer to that to then determine if we need to do anything.
Okay.
Or what we need to do to address that. If it is a statute that needs to be fixed, this is the right place to do it. If it's something else, then we need to ask that question if this is the right place to do it or not and what we should do. But I mean, I'm not really ready to proceed any other way without knowing that.
Representative LaJoy?
When, excuse me, when in negotiations, has the union up to the party ever requested longer than 6 months as a negotiation practice?
So our current contract with the union doesn't stipulate probationary period.
Okay,
It's not in our union contract, the ProTech contract. The only thing it talks about is probation is it just states at the end of your probation, you get this, but it doesn't state the extent of the probation.
What do we do from here?
excuse me, Madam Chair.
Yes.
So it would be up to the union to request that. In other words, to go beyond a 6-month probation up to a 12-month if necessary.
I'm not sure, because again, it doesn't state a time frame in the contract for your probationary period.
Okay. Thank you.
Representative Hassan Fuss?
I think the most prudent course of action is to table this, find the answer to that, and then determine how we proceed from there. With that, I'll make a motion to table.
I'll second that motion, because I think it's important that we do this.
Okay.
All in favor?
All opposed? Done. Thank you.
Take a break until 1. Is that?
Yep, so we'll come back at 1 o'clock. So Will? What do we do next on this bill? No. What do we do next on 2090?
Do you want this stuff?
Yeah.
laugh at me.
Okay, there we go.
Thank you.
Perfect, thank you. Good morning, Senator BB Center, Representative Hassenfuss, and esteemed members of the Criminal Justice and Public Safety Committee. I am House Speaker Ryan Fecteau. I have the privilege of representing my hometown of Biddeford, and I am here today to present LD 2165, an act to change supervisory authority over the Capitol Police, a governor's bill, which I am happy to sponsor. LD 2165 is an important step in merging the Capitol Police and Maine State Police, a transition that will help improve operational efficiency, manage resource allocation, and enhance crisis response capacity. Enhancing the partnership between Maine State Police and Capitol Police will strengthen existing information sharing and create a unified command in light of increased demand for services. Specifically, this bill will transfer supervision of the Capitol Police to the Chief of the State Police. It will reclassify the Capitol Police Chief's position to that of a State Police Lieutenant, who would serve as the commanding officer of the Capitol Police. It allows for gradual transition through the natural process of attrition so that over time, Capitol officers, as they leave their jobs, they will be replaced by a state police officer position. The current environment, as you all know, is more polarized than ever. And in turn, the volume of threats directed at public officials is on the rise. I know we all feel the impacts of this. Over the past 4 years, the Capitol Police has seen a 180% increase in threat complaints. These complaints were largely against members of the legislature with no regard for political affiliation or family situation. The Capitol Police have done a great job responding to the heightened demand, and I believe these changes will help us improve coordination even further and capitalize on all of our existing resources. Every public servant and elected official deserves to feel safe. I encourage the committee to pass this bill to help achieve this goal. I also understand that DPS has been in conversation with bargaining units and is putting forward a friendly amendment as a result of those ongoing discussions, which I will let them speak to in more detail. I'm happy to answer any questions, but will mostly defer to the department who will testify after me. And I thank you for your time. I will also just mention that as you likely know, as Representative Nutting knows, having served on legislative council in the past, that there's been a close relationship between legislative council and Capitol Police. The leaders of both parties that comprise legislative council has worked with them very closely on making sure that the needs of the legislature are the needs of the legislature is met when it comes to public safety and the safety of public officials. I think we have made a lot of progress in the time that I have been in the legislature to enhance the work of Capitol Police. And I think this is the next natural step in making sure that in this new environment that we are in, that they have all the resources that they need to do their jobs effectively. And I think this will be a welcome transition from my perspective and a good step forward. So thank you.
Thank you. Are there any questions for the speaker? Seeing none, wow.
Thank you very much.
Okay. Is there anybody who would like to speak in favor of this legislation?
Yes, good afternoon. Mike Sostrick. I'm the Commissioner for the Department of Public Safety. I don't have anything in writing today. I did want to discuss the kind of the context, the history of kind of how we got here as the individual that ultimately made the decision at the Department of Public Safety to make this move. And just tell you how we kind of walked through this position. I do appreciate all of your patience as a committee. I know there was a December briefing, which initially this was on that agenda and got bumped. It's been touched on in various AFA hearings, budget hearings, and now we're finally get a chance to come in and say hello. So I also appreciate Speaker Fecteau and Madam President Daughtry for sponsoring and co-sponsoring this bill. I do appreciate that. To say the least. So a little history here. So I did come in with Governor Mills in 2019. In that time, I've had two different police chiefs. This would be a third hiring process or transition, if you will. That's not uncommon in 7 years. Nationally, it's like 3 to 5 years for police chiefs. So to have a couple in a 7-year period is pretty traditional. But what I will tell you is that After the second time with Chief Garvin and then Chief Clancy, I really looked at this as an opportunity. I think change is an opportunity for all of us. And the very first thing that I did when Chief Clancy went out on administrative leave is I started meeting with all of the individual employees across the Capitol Police Department. So there are 30 total. 16 and a half because there's an interim in there on the or a part-time on the law enforcement side and 13 and a half on this on the civilian side. So ultimately I met with 26 of the 30 one-on-one. Wasn't a mandate. It wasn't a, you have to come in and talk to me for an hour and tell me your life story. Some of those were 15 minutes. Some of them were an hour plus. And that's just an opportunity for me to say, so how long you been here? What's going on? How are things? Good, bad, and different? Married, kids, what's your commute like? Which was great for me. I don't get an opportunity to meet with folks as much as I would like in that setting. So consistently throughout those one-on-ones, what I did here is passion and respect and professionalism. They care about the mission. They care about you. They care about this complex. And they were looking for help. I think they were looking for additional resources. They were looking for a different structure. I'm a municipal guy, so I retired from the Portland Police Department years ago. Good, bad, or indifferent, I'm very proud of that experience. And when I heard very experienced officers from Capitol Police tell me like, hey, maybe there's an opportunity here for us to kind of roll over into the state police, an existing structure that's currently here, that we work with every day, that we have these two different systems that work together and there's mutual aid and there's all this stuff. However, it's still two different sets of policies. It's two different commands. It's still two different resource buckets. So when they came to me with that, maybe I would have ended up there myself as I did this review, but I really was like, wow, that was very interesting, right? From a law enforcement perspective or a first responder perspective, to make that offer or to throw that on the table is a big deal. You don't hear that very often, for sure. So I started looking at it through that lens a little more. And I took a couple additional months working with Lieutenant Steve Trahan, who was traditionally the number 2 and was the acting chief in that lead. And Steve was great. We formed that relationship where he's looping me in as we would normally in any other chain of command for first responders, which kind of brought me in the loop to the day-to-day operational stuff. What are we dealing with every day? What are our officers faced with every day? What are our screeners faced with every day? So started to get into the weeds a little bit, which was great on my end. It was actually fun to do some of that operational stuff again. So Steve has been great throughout that process. So then we get a little further into it. I actually talk to the state police and say, so what would this thing look like? If we made a move of that nature, what would that actually look like? And they gave me some proposals and some different options. And then I started talking to the governor's office. I talked to others. Throughout the last year, I've been speaking with legislative leadership about safety and security issues, revamped our whole approach to the legislature as you were coming in for this session. I think ultimately, because of schedules, we got 5 minutes to come talk to you, but we had briefed up a bunch of information about to do your first drill for a fire alarm example, to create the screening center in Cross, which was a long time coming, even on a temporary basis now. So a lot of those conversations had occurred. And then December, I end up talking to Lieutenant Trahan again and saying, listen, this is where I'm going to go. And I want an opportunity to talk to the whole team to let them know that this is where we're heading. And then Steve said, well, I got a staff meeting tomorrow. I said, all right, well, I guess we're doing it tomorrow, right? And I sent an email out and then I talked to the team in 2 separate meetings. What I did not do, and which was an epic failure on my part, is I did not talk to MSLEA and Director Kevin Anderson, who was here today. He was surprised by this whole thing. Never should have been. Complete failure on my part to not loop them in. Just legit run around hair on fire, pulled the trigger, and was like immediately when there's media stuff and people are talking, I'm like, that's rookie move 101. That's dumb. And I did it. That's all on me. That's not on anybody else. It's not on Lieutenant Trahan or anybody else. So that happened. And so then there was a request for impact bargaining, which we've been involved with and had some conversations over the last probably couple of months now with scheduling stuff to try to address a few different issues that have been brought up. Really good issues, good concerns, things that I think we've largely taken care of. But Director Anderson can certainly represent his interest on that side and talk to you however he'd like. So I think we'll have another meeting at least scheduled to try to figure some stuff out. I think issues that were still on the radar And I actually had to ask questions. I've been at this a while. I'd never done impact bargaining, right? So I talked to HR again, like, is that a confidential thing? Can I even talk about what we're doing? Is that negotiations behind closed doors that says we can't do that? And they said, well, we don't have ground rules for impact bargaining, so we can essentially talk about whatever. But on our issue, just to keep it at 100,000, there's like pay parity, there's seniority and how that's defined. And then there's actually the language, the legislative language that you have in front of you. I think we ultimately came to an understanding and agreement on the language that will give you the amendment, the friendly amendment Major Stevenson will provide here in just a second. The pay parity issue, I'll just tell you that I think that can be an ongoing conversation. However, the state looks at this as, do the duties change? Does a Capitol Police officer's duties change? And if they don't change, that's FJs, that's reclasses that you see all the time in the budget. If they don't change, does that merit an increase in an hourly rate? And in this case, we don't believe that those duties are going to change. I'll talk a little bit more operationally to say that the whole idea here is that we have amazing personnel, right? They're highly skilled. We've got folks from brand new police officers that are people that have been in the game for 50 years. Of those 16 cops, there's 3 of them that have been a police chief in other locations. That we have the right people doing the work in the hallways here for sure. So when I looked at models, how do we transition? There's a model where you blow the whole thing up and everybody leaves and we start all over again. There's a model where we say, okay, tomorrow everybody's a Maine State Trooper. But I think all of those things are disrespectful to the employees that we currently have. So the idea here is that as a Capitol Police officer leaves for whatever reason, that we would backfill that through attrition with the Maine State Trooper. So I'm a police officer. I decided to resign and go work for the federal government doing something else. And now how am I going to backfill that? I'm going to put a trooper into that position. So that transition may take a long time, to be quite frank with you. But another one of my goals in coming in here today in this process is to come in with a 0 fiscal note. As of right now, I don't need any money to make this transition. I will need money down the road, as an example, if I do this attrition rate, I lose an officer, I replace it with a trooper. That's about $100,000 more than a Capitol Police officer. A lot of that is equipment and cruisers and all those other things. There's also a piece of that that's pay and benefits right off the top. So if I came in here and said, well, I need $1.7 million to make the transition, I'm going to do the whole thing right now. That just changes the whole deal, right? And we have a very tight fiscal year. Everyone I've ever dealt with has been tight, and is certainly tight now. So in this case, if we do this through attrition, and you'll see it in the bill language, you already have it in front of you. The first opportunity to do that would be in September of 26. That'd be the first time if there's a vacancy on the law enforcement side that we could replace that with a trooper. So every time there's a vacancy, we would go through a reclass conversation with HR, make a determination whether or not that's good or bad. And then we would request funding in the next, whatever, supplemental, biennial, whatever it is, just like we would any other reclass. And we'll work that process throughout. So that's the attrition transition piece as we go. Kind of touches on the pay parity bucket. There's a seniority bucket in there and how that's defined. From our perspective, I think we're in a good position there. If we can't come to an agreement by September on exactly what that looks like, we will revert back to the existing MSLEA contract, which is the way we should do it. And then we'll deal with the troopers a different way. And again, the third leg is the friendly amendment language that you have in front of you. That's real quick for something that was pretty in-depth over the last 6 months or so. There's a lot that's gone on, a lot of conversations, a lot of good conversations. I think we've learned a lot. Again, I would say I appreciate Director Anderson and his work and his team. We got a great union rep at Capitol Police that does the work every day. He's been an incredible asset to have at the table. What does this really look like? What do you think about that? So all of those things are good. From a command staff perspective, this would be plugging into the Maine State Police. So Tyler Stevenson as the Major of Support Services, and he spent some time over here this session. You know Tyler from years past as well. Ultimately, that would fall under his shop. For whatever it's worth, it's me, and then it's the colonel, and then a whole command staff. And Lieutenant Greg Roy is the current lieutenant overseeing Capitol Police. He's absolutely the right person for the job. And Greg's amazing and has been very, very helpful with that transition and rebuilding trusted relationships and answering questions and all that stuff that goes along with that. So again, there's a lot there, but I'm happy to answer any questions that you may have about how we got here and why.
Representative Perkins?
Thank you, Madam Chair. Thank you, Commissioner. Can you give me the numbers again of the people you had on each side of the house?
So 30, and it's 16 and a half on the sworn side, 13 and a half on the civilian
On the
side.
sworn side, 16 half. Do you have any, do you have green pins or is it just up?
We have 3 green pins.
You have 3.
Yep. Which is statutory authorized, the only agency in the state that's
That's what-
authorized for full-time employment as a green pin.
So would that immediately change under this new model? They would fall into that regular attrition under the
Yep.
section 429.
Absolutely. Yeah, nothing on their work changes at all. And again, based on this circumstance, they're full-time employees as law enforcement officers. They can't get in chases, all the stuff that you're already familiar with. But they do a great job. A lot of specialty work that they're doing on our behalf, and nothing would change for them at all.
Okay, thank you.
Representative Nutting?
Thank you, Madam Chair. Thank you, Commissioner. Like Speaker Fecto, when I was in the position of working closely with the Capitol Police, I too enjoyed a good relationship with them, as I'm sure he has as well. But what I don't know, or what I don't remember, likely, is who supervised the Capitol Police? Was it the executive director? Was it the Commissioner of Public Safety?
Right. The Capitol Police Bureau, as they would call it, I would call it a full-service law enforcement agency, has always fallen under the Department of Public Safety since it's been a law enforcement agency anyway, which has been a long, long time. So that chief works directly for me like the rest of the 10 bureaus.
And works then through the executive director, perhaps, for scheduling? Or
Is this the
no?
executive director of the legislature? The
Yeah.
executive director of the union? What
Executive director of the legislature?
No, then there is no direct supervisory connection there. There is an absolute, probably daily conversation that's happening in both directions with Suzanne, who does an amazing job. You guys all know that. She's a great partner in this, but that's not a direct connection there.
Okay, and the only concern that I have, well, I might have more than one, but the only concern I have is that when you get down the road, and let's say you're 16 employees now, there are 8 Capitol Police still remaining, there are 8 new troopers that have been replaced.
Sure.
I assume that they're going to be operating at a different pay scale. Maybe I'm wrong, but do you foresee that there will be some disconnect between the 8 people who are working related to the old Capitol Police situation and the 8 new troopers filled in?
What I would say to that, sir, is that I do believe that there's going to be another union negotiation. I believe it's next year when they come back to the table, right? So as I sit here today, I would tell you that I don't foresee any change in duties for the Capitol Police officers that are currently here or would be here in that 8 and 8 scenario, that hypothetical that you just gave. However, if I'm wrong and Kevin goes to the table next year and says, well, Mike said this and their duties have changed in this way, and we want to negotiate them a higher rate to be more for pay parity sake with the troopers that they're working with every day, they're going to have an opportunity to negotiate that every time a contract comes up. If not with an FJA or a reclass before that. The scenario we're in is that virtually every position, if not every position at Capitol, every position at the Maine State Police were just reclassed within the last year, 2 tops. So everybody has been there. What are your new duties? What does that all look like? And that's impacted those pay rates one way or the other. So I do think this is an ongoing process, just like any other process when it comes to pay.
Thank you.
Representative McIntyre?
Thank you, Madam Chair. 2 quick questions. First one follows on with Representative Nuttings. During your testimony, you indicated the attrition model is going to take a long time.
Yep.
But you used the bunny ears. Do you have a best estimate?
So we have officers that have 17 years left, as an example, till retirement. And as you know, we know I don't have any idea how long people are going to be around. They may be around for 25 and they could have left at 17, right? So that does vary. For the first time ever, we sent a brand new police officer to the academy last year, right? So that's a full career ahead of them. In that way, there is a mechanism in place that we've discussed to, if you want to be a trooper, then apply to be a trooper and follow through with that process. And all of those things, we're adding some specialties that they have access to, that the Maine State Police currently have, that they don't have as a Capitol Police officer. So there's a lot of different options in there. But that, I say bunny years because it could be brand new. They could leave tomorrow, right? It's hard to tell.
All right, fair enough. And then thank you for that. And then the second final question is, in the sponsor's testimony, it promotes that this proposal will support operational efficiency, crisis response capacity. And you know my background, so you know where I'm coming from.
Yeah.
In reading the bill language, do you have a copy in front of you?
Yes, I do. Yes, sir.
I was looking at some language that caused me a little bit of confusion.
Okay.
The bottom of page 2, paragraph 2, or section 2. These rules are suspended to the extent necessary at any time the commissioner or of public safety or the designee determines that an emergency exists within the facilities, except that the commissioner or designee may not suspend the rules governing the legislative offices without the consent of the legislative council. So my question there, or concern, if you will, is say we have an active on the property.
Yep.
Does that, to me, paint the picture that the authorities of this team may not engage a lockdown without consult from above first?
No, I would think in an emergency situation, they would have that authority. As alleged counsel with security responsibility over the state house, right? Capitol Police would have Cross, they would have the state house. The security regulations are all over that, is coming from alleged counsel. We're working with them. There's also language that talks about, as these rules are drafted, consultation with whoever's the commissioner and the colonel of the state police, just filling in where it used to be the chief of the Capitol Police, right? So working together, which happens every day for security reasons. If there's something active, then I think we're going to do what we need to do. And then we're going to make that notification as fast as humanly possible.
Okay.
I will tell you something that I screwed up years ago, which was we locked the doors because it was a large protest that was planned out here. And we ended up locking the doors without checking. And we had notice in that case. And we didn't use the notice to make the proper notification, which we should have. So that's a different scenario. If it's live, if it's active, we're going to take care of business and we'll figure it out later on. I don't think there's going to ever be any issue there. But if we have time, we should call Suzanne. We should check in with the leadership that lead that LEDS council and just say, hey, this is what we're thinking. And you can never guarantee anything. I'm fully expecting they're going to say, that's a great idea. You got 5,000 people out front. You want to lock the doors? Okay, you should do that. I should have just asked the question, however. And that, I don't know, that was probably Chief Galvin. That was probably 7 years ago or something.
Okay, thank you.
Sure.
Representative Ardell?
Thank you, Madam Chair. And thank you, Commissioner.
Yeah.
There is, as you know, there's a pretty significant pay disparity between Capitol policemen and troopers.
Yep.
Let's say the sort of Capitol troop, for lack of a better term.
That's good terminology.
Was blended, say, half and half. Is it, if the same duties are maintained by all the employees in that troop, is it possible that the Maine State Police troopers who are assigned to the Capitol troop could be subject to a reclass downgrade because they're not performing the duties, they're performing the Capitol Police duties, and they're not performing the duties that they would otherwise in the field?
Right. I do think that the baseline idea here is that a trooper is still going to go through the additional 8 weeks of the RTT, the recruit training trooper would graduate in a group on Friday, right? They're still going to have statewide responsibilities to go do whatever we deem necessary based on the mission emergencies, whatever they need to do, which is going to be a different skill set in a different duty set than what we have here. I've never seen, I don't know if you have a reclass that would come down in nature, but I've never quite seen that one, but maybe you have on the federal side, but I haven't seen it.
I have. And,
Okay.
and what it turned into was a be careful what you wish for scenario.
Yeah.
There was a group that requested a reclass and got exactly the opposite of what they wanted. So I think my only real concern as a legislator would be, you have this sort of two kind of mixed group that is potentially doing a very similar task, but being compensated very differently. And I think that's probably my greatest concern.
Sure.
Both for the troopers involved and also for the Capitol policemen. So,
And I do think it's a valid concern. I really do. I mean, when you think about pay parity and respect, at the end of the day, money and retirement pay and benefits comes down to a respect issue to a certain extent, right? I mean, that's what that speaks to that. But I do think in a scenario like this, there's going to be a lot of opportunities for those negotiations to occur over time. And I do believe that next year would be that first time. As it stands right now, there's not a trooper, even an opportunity to have our trooper over there till September. So you're talking 7 months or something between now and then. When and if that happens and we start to see an issue, then maybe we can readdress it then.
I could see that being a morale, a critical morale issue because it's very difficult to be doing the exact same job, alongside someone who's being compensated at a much higher level. So if that could be kind of kept, to the forefront, I'd appreciate it.
Absolutely. So I do hear what you're saying. And I also think that if a Capitol police officer remains here while that trooper that's next to him paying something else ends up going off to take care of the rest of their mission, the rest of their job assignment, the rest of their classification, then that's where that difference could come. But I absolutely hear what you're saying. Completely respect that. Sure.
Representative Perkins?
Thank you, Madam Chair. So you have a mix of sworn officers and other security personnel. As it stands now, do you anticipate continuing to run that same model? Or according to that attrition where it says, as a Capitol Police officer position becomes vacant, you're not going to replace the non-sworn
No.
security personnel with troopers?
Super point. I mean, for us, so almost a 50-50 split, right? 16 and a half. So the civilian side of the house, there's no impact whatsoever. Their job doesn't change. The classification doesn't change. There's a new, in this case, lieutenant that's at the top. There's absolutely zero intent to switch those out with whoever. They do an amazing job.
But they will just become then direct employees of the state police.
Correct. Yep. Yes, sir. Yep.
Thank you.
Yep. Good points.
Are there any other questions for the commissioner? Representative Hassenfuss?
Yeah, well, thank you for answering, the first one about additional duties, and it sounds like the state police are going to have the additional duties we expect of state police.
They're going to have
Yeah.
that responsibility. They're going to have that training. They're going to have that capability. How often we're pulling them off to do whatever, I can't tell you.
But that's there. So that's one discrepancy. But do you know of like other offices, either other, police agencies in the state or perhaps out of state that have had a transition plan similar to that, where they slowly implement, higher paid officers with duties other than, the rest of the?
I don't know one that has done that particular transition model. I think if you look at Massachusetts, you look at New York, you look at a bunch of other states, they have done one of those where, okay, now you're a trooper tomorrow. And if you can't go to the 8-week RTT on top of what you got, then you're not going to be here anymore. Which I think in our case is disrespectful and completely unnecessary based on the skill set and the personnel that we have. So there's a lot of those different models out there. I think this works the best for us based on everything that I've seen.
But have you seen anything like this elsewhere?
Nah, and I don't know that I would, considering 50 states and how transitions occur, but the ones that I'm aware of are not followed this model.
Are there other questions? Thank you very much.
Yeah, thank you very much. Good to see you again.
Is there anybody else that would like to speak in favor of this legislation?
This is the friendly amendment.
Okay.
I have one copy. I'm sorry. You can have that. And then I do have my copies of my testimony.
Okay. I'll put this here to the moment.
Welcome.
Thanks for having me.
Yep.
All set?
All set.
All right. Good afternoon. My name's Tyler Stevenson. I'm providing testimony on behalf of the Maine State Police and Department of Public Safety in support of LD 2165, an act to change supervisory authority to the state police. Supervisory authority over the Capitol Police, sorry. This bill would transfer supervision of the Capitol Police to the chief of the state police and reclassify Capitol Police Chief's position to that of a state police lieutenant, who would serve as commanding officer of the Capitol Police. Through natural attrition, as Capitol Police officers vacate their positions, those positions would be reclassified to state trooper positions if funds are available. On December 15th, 2025, under the direction of the Department of Public Safety Commissioner Michael Soschuk, the state police assigned a lieutenant to supervise the day-to-day activities of the Capitol Police. This decision followed months of careful consideration and evaluation of all options with the goal of providing the best possible policing and security services. The women and men of the Capitol Police are professionals who take great pride in their work, and I have been impressed with my interactions with them and my observations of their performance. The benefits of placing Capitol Police under the umbrella of the state police are numerous and positive for both agencies and for the Capitol complex. Passage of this bill will result in improved resource allocation, greater operational efficiency, we've already heard that, and enhanced crisis response capabilities. The state police have access to greater personnel resources, advanced technology, investigative support, and specialized units, including the tactical team, crowd management, K-9 bomb squad, and major crimes units. Merging the Maine State Police standards with the Capitol Police would ensure a uniform and consistent law enforcement standard across the Capitol complex. Capitol Police officers would gain direct access to state police reporting systems, technology, fleet resources, policies, and command structure. The Maine State Police also maintains a fully functional and robust Office of Professional Standards, which ensures accountability and regular inspection of police services. Integrating the Capitol Police into this environment would extend the benefits of this oversight and support the Capitol complex. The current political threat environment is higher and more dynamic than at any point in this century, and it continues to evolve. As it stands, the State Police Executive Protection Unit, the EPU, and the Capitol Police work well together, but they are separate organizations operating under different executive administrations. If the state police were charged with providing Capitol and security services, providing police and security services of the Capitol complex, it would be natural for EPU to fall under the command of the same entity. Benefits of this alignment include improved communication, enhanced information, intelligence sharing, and consistent training policies and equipment. The bill would create a critical force multiplier for the complex. Capitol Police and EPU are currently being stretched by today's threat environment, and having troopers assigned to Capitol Complex who possess training, education, and experience to supplement EPU staff as needed will be essential in addressing both current and future safety concerns. A single chain of command would promote clear communication, a shared understanding of mission, a direct flow of information from ground level to executive leadership regarding both Capitol and gubernatorial security. In the past, these missions have at times involved duplicative objectives and strategies. The state police has experienced significant success in recruiting and retention over the past 4 years. Since 2021, we've hired 108 troopers, and we believe we can bring the success to the Capitol Police, which has historically struggled to fill its ranks. This structure would create a more robust command framework, including the Maine State Police Major of Support Services, a lieutenant colonel, and colonel under the authority of the Commissioner of the Department of Public Safety. And finally, over the past 4 years, the threat environment has changed dramatically. In 2022, the Capitol Police received 6 complaints involving threats to the complex or legislatures. That number increased to 23 in 2023, 53 in 2024, and 111 in 2025. This bill represents the necessary and proactive steps towards providing the resources necessary to mitigate today's threats and prepare for those tomorrow. On behalf of the State Police and Department of Public Safety, I appreciate your careful consideration of this issue. I thank you for your time, and I'd be happy to answer any questions that you might have.
Are there any questions for Major Stevenson? Yes, Representative Perkins.
Thank you, Madam Chair. Thank you, Major. I'm just, in the last couple of seconds, had a quick look over your amendment. So the 2 primary changes I see are in paragraphs 3 and sections 3 and sections 4 is 2908. One is that final sentence on 4 where basically it says we're not going to get rid of anybody except for by attrition, which I'm fine with that. And then the other is the chief of the state police. You crossed that part out. Are there any other major changes to this amendment that I
No.
don't see? Okay.
That's the friendly amendment in agreement with MSLEA. And the reason why the chief being crossed out, it was not our intent at all, but there seemed to be some confusion that if troopers are assigned to Capitol Police, that they would not have to fall under a Capitol Police supervisor. It would be directly in line with the colonel, and that is not our intent. If they're doing Capitol Police business and there's a Capitol Police supervisor, they will answer to that person.
Follow up, Madam Chair.
Please.
Thank you. So the other thing you mentioned in your testimony is the EPU. Is there anything in here that specifically designates the EPU falling into this capital troop, or is that something you guys would
No.
be able to do administratively or through rulemaking or policy or some other
That
way?
would be a strategic plan to combine those units, management rights to reorganize and combine, take EPU out of special services and put it with the capital. I think it fits naturally there.
But that's nothing you actually need us to do. You
No.
guys can handle that on your own.
Yes.
Okay.
Thank you.
Thank you.
Are there any other questions? Seeing none, thank you very
Thank you.
much. Is there anyone else that would like to speak in favor of this legislation? Do we have anybody online? Is there anyone that would like to speak against this legislation? Welcome.
Thank you. There's two parts. The testimony.
You could just cross.
I will.
Yeah.
And then so amended.
Thank you.
Thank you. Thank you. Welcome.
Thank you. Good afternoon, Senator BB Center, Representative Hosfus, and distinguished members of the Criminal Justice and Public Safety Committee. My name is Kevin Anderson. I am the Executive Director for the Maine State Law Enforcement Association. It's not every day I get to speak against a governor's bill. That's a little bit intimidating, but here we go. So in this role, I represent over 400 state law enforcement officers to include game wardens, Marine Patrol officers, forest rangers, and Capitol Police officers in collective bargaining and labor-related matters. Prior to this, I was a game warden for 12 and a half years in this very district, the Augusta District, and a game warden investigator for a little over 13 years. I served as a cadre for the 14th and 15th Maine Criminal Justice Academy Basic Law Enforcement Training Program. In these roles, I had the pleasure of working with members of the Maine State Police daily. I say this to make it clear that none of this testimony today is meant to indicate that I believe that the Maine State Police officers do not deserve the compensation and recognition that they receive. They are some of the finest law enforcement officers in this state. That being said, I am here to testify against LD 2165. The title of this bill is misleading, and the changes go far beyond the stated title of the bill. Just to address, to get off script a little bit, but it was mentioned that Capitol Police officers brought this idea forward when they were spoken to. And I've spoken to my folks. The idea was they welcomed and still do, which is why the amended bill was given to you as well, to have state police command structure take over supervision of Capitol Police for consistency purposes, but not to have their jobs taken over by the Maine State Police, just to be clear on that. The Bureau of Capitol Police has been in existence in one form or another since 1968. There's actually a very in-depth explanation of the history of the Capitol Police on the State of Maine website that goes back to 1968, talks about its evolution, which in the last 5 years has been pretty dramatic. Within the past 2 years, both the Maine State Police and Capitol Police engaged in the reclassification process with the state. That process is initiated with the submission of an FJA-1 functional job analysis, a document that provides a detailed work description. The reclassification results provide employees in those positions with a pay grade, which results in the placement on the state pay scale. The most recent pay scales indicated that state troopers make between $12 to $15 more an hour than Capitol Police officers in the same place on the step progression. That depends on where you are on the progression. State police detectives make between $6 to $7 more an hour than a Capitol Police detectives, and then $7 or $8 more for state police sergeants, and 10 to 12 more for state police lieutenants. And a state police lieutenant makes the same or similar hourly rate to the chief of police for Capitol. These numbers do not include standby pay. In some classifications, amounts to tens of thousands of dollars a year. A benefit Capitol police officers do not get. These pay parity gaps may be in fact larger, whereas it does not reflect pay increases awarded from recent contract negotiations for state police officers. These numbers do not take into account the fact that Maine State police officers also get issued a take-home vehicle, and most Capitol police officers do not. Additionally, state police officers are assigned to a more expensive retirement plan than Capitol police officers. They're on a 25/55, and state troopers are on a 25 straight. Numbers provided by the Commissioner of Public Safety, as you heard, makes that pay parity difference annually of about $100,000 to replace one Capitol police officer with one state trooper. In a press release issued by the Department of Public Safety, it stated this change was being made with the future in mind, and that threats against our legislators and properties continue to grow. And that may be true, and the Capitol Police Department has grown in recognition of this trend. The Capitol Police has been provided funding by this legislature to add a detective position, a bomb dog and handler, a new secure entry kiosk with screeners, and a Capitol Police officer in the Cross building next door. The Capitol Police recently sent a newly hired officer through the Maine Criminal Justice Academy Basic Law Enforcement Training Program, also known as the Blue Pin or Full-Time Law Enforcement Academy. This is the first time in Capitol Police history that I'm aware of that this bureau dates back to 1968. The current law does not require it, but the prior chief recognized the increased demands on Capitol Police officers. All officers hired over the past several years with the Bureau of Capitol Police are experienced full-time law enforcement officers who previously held law enforcement jobs as police chiefs, police lieutenants, police detectives, and police officers. They bring life and law enforcement experience to the Capitol Police. The role of Capitol Police officer is probably one of the most forward-facing law enforcement positions in the state. I have done patrol work in a municipality. I've done deputy sheriff work. I've done game warden work. This is probably one of the most forward-facing law enforcement jobs because every day you don't have a place to go. It's always right in the face of the public. And some of the people that, when I took the job as a game warden, they said, don't take the Augusta district. It's a toll-free call to Augusta. And legislators, you never know who you're dealing with, but it was never a problem because if you treat everybody the same, it doesn't matter. But it is intimidating because you are the lawmakers. And that can be an intimidating position for somebody in law enforcement, but they do a very good job of it. They've done an exceptional job, and there is no indication that they are not up for this task. They have been known, there are no known complaints indicating they have not been keeping up with the demands. This bill indicates that the replacement of Capitol Police officers will occur through attrition, and the commissioner and the major and the lieutenant colonel have met with us. We are engaged in impact bargaining, and we have agreed to this, basically trying to mitigate the damage. Essentially, our folks basically say, I just don't want to lose my job. That's their major concern. They do not want to be displaced and lose their job, but there's some other issues that come with that. So this is a way to make sure that they don't lose it by just being fired. We didn't want them just to be axed, but this goes through attrition. So that is one benefit to this bill that has been amended, and I appreciate the commissioner's willingness to do that. So this bill indicates the replacement of Capitol Police officers will occur through attrition. It was also stated in an email sent by the commissioner to Capitol Police staff. If this is true, then the transition could take place over 25 or more years. The new officer that was just hired, he has to do 25 years to get his normal retirement. If he reaches normal retirement age, he could stay for longer because he's not on a 25-year straight plan. He's a young guy. He could stay till he was 55, 60 if he wanted to. So that could be much longer. The statement released by Public Safety indicate that this change will improve resource allocation, operational efficiency, and crisis response. There's currently no specific issues with any of these that we're aware of, and I have asked Capitol Police officers that I represent if has there been any issues with communication, crisis response, or operational efficiency, and it didn't surprise me to hear that there was none. The commissioner recognizes the impact of this change in his email to staff, where he states this is a major change that will impact you both personally and in a professional manner. That is in fact true. This bill will cause chaos, confusion, and uncertainty within the Capitol Police. This change will mean that employees within the Capitol Police could potentially be operating under 3 separate contracts, which means 3 separate sets of work rules. State troopers, sergeants, and detectives are represented by the Maine State Troopers Association. State police lieutenants, Capitol Police lieutenants, and Capitol Police sergeants are represented by the Maine State Law Enforcement Supervisors Association, or FOP. And Capitol Police detectives and Capitol Police officers are represented by MSLEA. During impact bargaining held with the Department of Public Safety, it was revealed that troopers assigned to Capitol Police role will wear state trooper uniforms, and Capitol Police officers will wear Capitol Police uniforms, doing the same job. Currently, the department had not agreed to address the huge pay parity issue with this bill if it is enacted and it begins to be implemented. So we're still working on that. We're still engaging, but as of right now, there is no interest or desire to do any pay parity changes. Capitol Police officers will lose the opportunity to promote within the Capitol Police unless they want to apply to be to the Maine State Police, participate in the hiring process to be a Maine State Trooper, and then if hired, complete State Police recruit training, and then and only then at some point when there's an opening, the Capitol Police may apply for a position with a planned Capitol Police troop. In closing, I didn't want to come here and ask that you vote ought not to pass on this bill without offering a solution to this problem. What I would ask, a good step forward would be, and I had talked to Matt Clancy with this before he got done, but is make this is a full-time job. And majority of the people here were people with full-time jobs. They were law enforcement chiefs, lieutenants, detectives, worked in pretty high-profile cases. It's changed the law to require that you have to be full-time. Either you possess a blue pin, or once you get hired, you have to complete the Blue Pin Academy. It would obviously be prospectively moving forward because you have folks here, which you probably know, like Officer Laverdier. You would never guess that he was a green pinner because he's very well experienced. He does your training here for legislature with active shooter type situations. And he is very good, with his with the public. But he would be one of those people that would be affected if that happened. The other option is the other recommendation is to keep the state police lieutenant in place as supervising the Capitol Police, and then either find a new chief or leave that lieutenant there. The guys are really happy with Lieutenant Greg Roy. He's done a great job. And that's, I think, what they wanted. They wanted some consistent chain with the state police, but not for their jobs to be replaced by state police. The price tag associated with this takeover would be enough to double the number of Capitol Police officers that were to be done all at once under the current Capitol Police structure. So I thank you for your time. I'll be happy to answer any questions that you have at this time.
Are there any questions? Representative Ardell?
Thank you, Madam Chair, and thank you, Mr. Anderson. I hadn't actually thought of this until you brought up your testimony. The lack of promotion potential within the existing Capitol Police group, I think, is very problematic because it creates a ceiling for their careers unless they're forced into a position to do something else or make a move. Do you have a suggestion for an amendment on that, or how they could be incorporated in a more, I don't know, equitable way?
Well, I think the amendment that I propose is it does change. Basically, what's happening now is it permanently places Greg Roy as the lieutenant from state police, taking over the overall supervision of Capitol Police. It leaves all these people in place. You have guys like Ryan Frost. You talk about doing the job like it's different, and understandably, state police is statewide, but these guys get into stuff that you wouldn't expect them to get into. Ryan Frost left the chief job from Winthrop Police, came here. Within 2 months, he was involved in a police involved shooting incident, backing up his son in the city of Augusta. So it does happen to these guys. They can get into similar things that a trooper can get in. It's just within this area, and they do leave this campus. They go to Riverview and other places, and you know, you can't. The plan is, from my understanding, is as soon as the Capitol Police Sergeant gets done, then it would be replaced by a state police sergeant. As soon as the Capitol Police Lieutenant gets done, it'll be replaced with a state police sergeant. So that's the plan. So there is no opportunity. You can't go from a Capitol Police position to a state police position. There's unit determination already done where MSLEA covers Capitol Police officers, Capitol Police detectives, troopers are a different bargaining unit. So you don't go back and forth. There's been some proposals to allow these people that are already here to go ahead and just go to the RTT if they choose to complete that. That's been rejected. And I understand reasoning, but that's been a proposal, like just let them go through if they want to, and then they can become part of the state police troop assigned to Capitol in their original positions. But there's still some talks going on that. So we're not at the end of the road yet, but I think keeping the command structure the way it is within Capitol Police, and then making that a green pin, a blue pin job, or if you have to have somebody who's full time, and then you just increase it. You know, the pay range. Nobody's unhappy with their pay range. The legislature in the state's been generous in the last couple of contracts, and these guys are happy where they are. Obviously, if there are some problems attracting new candidates, there are some provisions under statute that allow them to increase pay to address those through stipends or whatever else to try to attract more Capitol Police officers. But they've got some great guys. I mean, Ryan Frost, Pete Struck, all these folks that came on new, Savannah Smith, Savannah Brennan, all these are full-time, like 8 years of detective, prior chief, prior lieutenant. There's been some good guys that have come over.
I'd hate to limit their mobility.
Yeah.
You know, just because of a sort of a reclassification, not a reclassification, but just a administrative change that would affect them negatively. So thank you.
Yeah, and it could be very confusing. I mean, I just envision down the road, like you mentioned, somebody mentioned, like you have 8 troopers and 8 Capitol Police officers. And now you have, in the current contract for MSLEA, Capitol Police officer seniority is time under Capitol Police. So when you come in, because they had people coming from all kinds of different places that might have had 20 years with DOT, and they came in, wanted to do their green pen, they wanted to do a Capitol Police. So they come in and they did that. Well, they came in and brought their state seniority to Capitol Police, but no law enforcement service time. So they wanted it to be based upon Capitol Police service time. So here you have that contract that says that, and then you have the troopers contract that has a different seniority piece. So if you have 8 troopers, 8 Capitol Police officers, and then you have a shift that goes out. Let's say we're working on an agreement for shift bidding. Well, who gets seniority? The 8 troopers or the 8 Capitol Police officers? Well, what if you have 8 troopers, 8 Capitol Police officers, 1 trooper sergeant, 1 Capitol Police sergeant? Who are they going to go to? It could be a chain of command issue that could arise that we aren't anticipating right now, where obviously you're going to gravitate towards the person that you work with normally. So I can just see those things happening when you have 2 different uniforms, and 3 different contracts potentially. And I think these guys are doing a great job. I'd like to see them stay the way they are, and then, have just that command structure the way it is now would work, I think.
Representative Perkins?
Thank you, Madam Chair. Thank you, Mr. Anderson.
Yes.
So along with your testimony, we were handed a handout that appears to have 2 different amendments. Or are they, well, I noticed maybe they are, the words are the same, but I know some of them are grayed out, some are.
Oh, that's because I did it I copied it in black. So I should have done it in red, but those changes should have been red. So what I did is took the state police bill, and then I just went through and so I didn't want to change any wording so they could see the wording that I changed, which isn't much. So if you look at, let me see if I can find a copy of that bill. Is there anything in particular?
Well, no, I was just wondering why we got 2 amendments, but you're saying the first one is your amendment, the one after that is the actual, what the state police are put forward, or what the commissioners put forward?
Look at that. I didn't realize there was 2. I could have copied 2 by accident. Is it the same thing, or is there different changes on both?
Well, that's right, because I don't believe that.
Should only be 1 amendment.
Okay, I did, the second one might be the the amendment that the major gave us, but that's what my confusion was. So you're saying you only have one amendment, which I'm assuming.
Yeah, we had worked on the first one, that the public safety had submitted, and we did agree upon that language for basically to attrition only was what the change was. And this one is the one I think should be the one that's in there, has to do with the just changing the command structure with the state police taking over the command part with the lieutenant.
Well, that clarifies my questions why there's two amendments there, but thank you.
Representative Abdi?
Thank you, Madam Chair. I just have a clarifying question, and I could have just missed it when you said it, but is that the understanding that the restructuring could result in loss of position, therefore loss of job for?
So with the current amendment that public safety has put forward would mean that it's only through attrition. So for example, let's say like 3/4 of Capitol Police are eligible for retirement right now. So you could have a mass exodus and have to fill in, 9 positions within the next budget cycle. So how it's set up now through this, the DPS bill is, let's say, for example, we'll use Jason Laverdia, for example. If Jason decides to leave tomorrow, well, I take that back, September 2nd, because that's when this would go into effect. September 2nd, then the state police plan is to, or the commissioner's plan is to fill that position, reclass it as a state trooper and fill that with a state police officer. So, and then there's if for the other position, the same thing, like a state police detective would take over for a Capitol Police detective through attrition. As they get done, they reclass it and make it part of a state police position.
Thank you.
You're welcome.
Are there any other questions? Yes, Representative Perkins.
One last question, if I may, Madam Chair. Thank you. Thank you again, Mr. Anderson. So in your testimony, you mentioned that the difference in the cost of operating per year, if all of those positions were replaced with troopers compared to what they have now, you said you could double that. Is that 1.7 million that the commissioner referenced in that difference of pay between troopers and non-troopers?
Right, because just the pay parity difference between trooper and Capitol Police officer is $100,000 a year from pay and benefits. It's pretty significant.
Okay.
Are there other questions? Seeing none, thank you very much.
Okay, thank you.
Is there anyone else that would like to speak against this legislation? Is there anyone that would like to speak? No, there's no one else in the room. Is there no one online? Okay. Okay. That is the end of that. Thank you very much.
I do have a question real quick.
What is your question? Representative Hasselfus?
Do we expect continued negotiations with a potential consensus from, or is?
So far, not yet, but potentially, yes, we have no problem still talking, but we've had answers to a lot of the questions that we put back bargaining and there's still some things that we work on.
I think it would be super helpful for this committee if in as expedited a process as we can to really pinpoint what the areas of disagreement are, and any decision points that this committee needs to make on those. I think that would be helpful if we can identify that. It seems like, yes, everybody is fine with having the, state police lieutenant be in charge, and that structure makes sense. All right, great. That's something we don't have to address, but if we can identify all of those consensus points and the points of discrepancy, I think that'll sort of help us figure out how to move this forward.
I mean, just so I'm clear, so we believe there were 3 issues, and I think 2 of them have been addressed. So the pay parity issue exists. The seniority issue, if we say we can't come to a solution that reverts back to the MSLE contract. But I'm not sure there's an issue. It goes back to the existing contract language as is.
Yeah, and so I guess the issues that I'm looking for are statutory issues, right? Because like some issues you're gonna be out there 10 years in the future based on contract negotiations. We're not gonna control those here.
Yep.
But anything that we need to actually control with, the financial allocations, probably which we won't even need to do through this budget. Future budgets, we can't really talk about, but the actual language in the statute addressing here's how we're gonna do it. Like, so for instance, my understanding is we can't, like, it is a shall. It is, so if a Capitol Police officer leaves under the statute, they have to be replaced with state police officer. Okay, I think that, that makes sense. That's in statute, that's a statutory program there. I know I'm rambling now, but I guess if my understanding is like, well, we need to put in law, if everybody agrees. Great. If there's discrepancies, let us know so that we can sort of do our role. The other issues that are non-legislative issues, we'll talk about those, but at the end of the day, that's not our decision to make anyways. So,
So I guess, sir, on my end, you have an amendment that we provided that both parties agreed to. I haven't seen Kevin's amendments. I will maybe.
It was the same one.
Was that the same one?
Yeah.
Okay. So I think on my end, we can go to
Yeah.
impact bargaining, have another conversation and then come back if that.
well, I guess a part of the confusion is the, testimony in favor and against, and if it's an amendment that everybody agrees upon, and perhaps this is for, Mr. Anderson, that like, if we agree on the language of the amendment, is there anything else for the legislature to do?
I guess to address the question, it's difficult. It's probably one of the most challenging things I've worked on.
Do you want to come up to the microphone?
Sure can.
Yeah.
We opening a work session?
No.
We're not opening a work session.
And
That's fine. So I think the most challenging part is that, yes, we agreed on how can we mitigate this, knowing that is a governor's bill. Like, how can we mitigate the damage to our people? And that was the purpose of the amendment, agreeing upon that amendment. But we still haven't reached an agreement on things like pay parity issues and stuff like that. So
Yeah.
had we done that, then I think we'd be 100% behind that, but we would prefer, that's why the other offered draft was there with just providing just a leadership change, the title of the bill versus that version.
Okay, yeah, so I
Okay,
think,
so I think we agree there are other things that we need to discuss, and I think you are already working on it, and I think in the work session, we'll find out more about it.
Okay.
So
Yes.
thank you very much.
Sure.
and just clarity on that for the work session, I think would be helpful.
So this meeting is over. Get good? Is there a motion to adjourn?
Motion to adjourn.
Is there a second?
And are some jackets assigned? Not
We don't need jackets. It's 50 degrees outside.